going to be. This is a House Judiciary Committee. It is courts and. This is a House Judiciary Committee. This is March 26th, and we have a number of bills that we're going to be hearing today. We'll start with Senate Bill 621. The Chief Justice is here, and if you'd like to begin, please.
Mr. Chair, Madam Vice Chair, members of the committee, I appreciate the opportunity to be here to testify in support of Senate Bill 621. I was here earlier testifying on an earlier version of the bill, so I won't go over what I went over before, but I'll talk a little bit about the differences. This is a bill that comes out of the task force to ensure the safety of judicial facilities. One significant gap that we have in safety that we're trying to address is the deficiencies in the number of security personnel in courtrooms in certain courts around the state, especially in circuit courts. We had an original version of this bill that did two things. One thing was to establish a minimum standard for security personnel that would be phased in over the course of 5 years that all courts were required to meet. The second thing that the bill did was to establish a reporting requirement so that the security agencies that are in charge of staffing courtrooms with security personnel would need to identify where they weren't meeting that standard and what was needed in order to get to that standard so that we could understand the fiscal implications of that and come up with a plan to meet it. We certainly understand the reasonable objections to including the standards as mandatory standards without the cost. And so this bill is revised to take out the first part of what was in the original bill, which is the standard that everybody would have been required to meet, and instead have only the reporting requirements so that we can really understand the full scope of the issue, understand what costs are at issue, and come back hopefully next year with a plan to implement and meet that standard. So this bill now is only the reporting requirement, which we think is a critical first step toward getting all courts to meet those minimum standards of security personnel in the courtrooms. With that, I would respectfully request a favorable report, and I'm certainly here to answer any questions if that's permitted.
Thank you very much. We appear to be having difficulty with the video, so they can hear us, but they can't see us, which is fine, so we can continue. But that's why we're having difficulty with the screens right now, and they're going to continue to work on that in the meantime. In the meantime, are there any questions for the Chief Justice? All right. Seeing none. Thank you very much. That concludes the testimony on Senate Bill 621.
Thank you very much.
Thank you. Now we're going to hear from Chair Wilson, House Bill 1378. Chair Wilson is going to be talking about his bill and significant amendments that he has made and provided to the committee. There were 2 sets of amendments that were created and provided to the committee. Members of the committee should look at the second set, the one that has arrived most recently. And if anyone would like copies of those amendments, we would be happy to provide them. You need to go to the desk in the Judiciary suite next door, and we'll be happy to provide copies of those things as soon as we can. I'm going to give Chairman Wilson some time to be able to describe the amendments because they are significantly different than those that or than what the bill reads right now. I will say that this is an issue that is one that we have dealt with for many, many years. It is always a difficult issue. It engenders enormous passion, not least from the sponsor of this bill, who quite literally has been through hell and back on this issue. I don't want there to be any applause, any booing, any outbursts of any kind, and if there is anything like that, you're going to be out. Thank you very much for that. Chairman, please begin.
Thank you, Chairman Clevenger. Madam Vice Chair, members of the Judiciary Committee, I stand for you today not as just a legislator, but somebody who has fought for years for the justice of survivors of child sex abuse. And in 2003, we passed the Maryland Crime Victims Act, and we made history. We tore down barriers for the silent survivors for far too long. And that fight, I've always said, was never about the money. I recognize a few of the faces from my first fights, and every time I've always said it was never about the money. It was about the truth and justice, and restoring the dignity to those who've had it stolen from them. And here we are again today. I thought for sure after the Supreme Court victory that I would be able to close this book, but obviously I cannot. And I was speaking to my daughter, my oldest, and I was telling her about the frustration, and I said, kind of let my kids know you're probably going to hear a lot of bad things about your dad on the internet. I said, you'll hear a lot of bad things about from people that I tried to save and tried to give a voice to. Because I remember when they started hearing things about their dad on the internet 10 years ago. And seeing the words, delegate was raped as a child. And so I was preparing them. And my daughter said she's like, Dad, you can be a good guy or you can be a hero, but you don't always get to do both. And I was like, I'm not a hero. She says, yeah, but you keep on trying to save people. And my oldest it was significant. She noticed the suffering the most because year after year coming back here and digging myself out of a hole when session was over. And it's difficult because I represent the victims. I represent the people of Maryland, and I know that we're in a difficult situation. And I think that, today was a good example of being outside here and being in front of the news, being challenged by an individual to remind me that my seat was being challenged. And in front of the news, telling me that I should care more about the victims than my seat. Ben Crump's-Klein, I'm sure you'll hear from him. Like I don't care about victims and giving everything, including my life and part of my sanity. But that was outside, so I'm sure you're going to hear some jewels today. But I had to prepare my kids first before I prepared y'all. I said, I'm sure they're going to hear about their villainous father long before I step out of these rooms. But the reason we're important is because this House Bill 1378, as amended, upholds the duty for the state to be accountable for all the atrocities committed within its facilities, while recognizing the financial constraints that come with governance. We're not a private corporation, and we do not have endless reserves, nor can we shift costs to the shareholders. We must maintain a responsible budget while safeguarding the essential services that millions of people depend upon, including education, public safety, and health care. Without this legislation, the potential exposure could spiral into the billions, the tens of billions, crippling local governments and essential services. We just got done having a budget hearing, and we talked about things that nobody liked. We talked about raising taxes and cutting services, and that was a $3 billion deficit. Some of these numbers are 10, 15, 17, $30 billion because the state avails itself to be sued. Currently, there are 4,500 cases that are filed with another 1,500 waiting. The door is perpetually open. There is no time bar, and although this bill, without the amendments, would have created one, that was never my intention. It was just a vehicle to get something done. I want to make sure people can come when they're ready. And currently, the occurrences aren't limited. And the way I'm sure you're going to hear some people want it is that each time somebody was molested, touched in a bad way, that should count as its own $890,000 occurrence. But as amended, what this does is this creates a liability cap adjustment. For any action filed on or before September 30th, 2025, the state's liability claims will remain at $890,000 per claimant. However, actions filed after October 1st will be dropped down to the Maryland Tort Claim Act. The Second Amendment is a clarification of the cap's application. This cap applies to per claimant, not per act of abuse, ensuring that the structure is a fair resolution without overpowering the state's resources. The third is a mandated alternative dispute resolution process. Requiring people to go through a process, setting up a process is important because the thing about settlement, and we all see this in the news, is you never know what really happened. I want to make sure that each dollar that is paid out is accounted for, that each of those individuals out there are held accountable, live or dead. Those names need to be made public. If the victims themselves do not wish to have their name made public, they can redact their name, but that situation must be made public for both accountability and for public safety. I don't believe that this undoes the progress that we have fought hard with the Child Victims Act. But it was never about financial gain. And some of you are very few now because I'm getting old. But I kept saying that, right? It's not about the money. It's not about the money. I just wanted people to have an opportunity to come and tell their story. And that's what they begged for. Giving survivors a voice, allowing them to acknowledge their pain, and making sure they know that Maryland heard them. However, what has definitely changed is our understanding of the fiscal realities. And I've, heard on the internet that this was an ego bill, that I was just trying to, make a name for myself, which is a really odd way to make a name. But it was really never about the money. It was really about a voice. I had no idea. And I think, just to put in context, most of the individuals that are abused or molested as a child, they feel that they're alone. And so even when I came up here, there's a smattering of people that I would meet. But never did I think that the number of claimants would be what they were. It was beyond my imagination that 4,500, if not more, because how could you predict that amount of malfeasance and institutional neglect? Why would I think there are so many? To the point where our state would easily be bankrupt. So I ask that you support House Bill 1378 as a decisive step forward to protect both Marylanders and the victims, still give them a voice. And as I'll say again, there is no amount of money that somebody could put in my pocket that will ever undo the pain and suffering that I have endured and my family has endured. So let's not pretend. And I want to be very clear. As I said, I recognize some of your faces from times past. You're getting ready to see a bunch of faces you don't recognize. A bunch of attorneys and plaintiffs' attorneys. They're going to tell you how much they care about the victims. Ask yourself, because I do, where were you when I was up here fighting by myself? When I was fighting Mike Miller and Joe Valero in the Catholic Church, when I was being ridiculed, when my colleagues were turning their back on me, they couldn't even be allowed to vote. And I would come back year after year. You're not going to recognize them because they've never been here. In the 10 years it took me to get this passed, not a single person you're going to hear from was up here fighting with me. Because they're not fighting for me, and they're not fighting for the victims. They're fighting for the money. And that's when it's become important. And it's with a lot of disgust. Not because of the fight that I had, but looking back and going, man, I really didn't ever have to fight by myself. All these people should have been here. I guess there was no money in it then, huh? I don't claim to be a hero, but please don't account these attorneys that come up next as heroes, because they're not. And I don't want to villainize them, but they're going to take their time to villainize me. I put everything on the line to support these people and to make sure that these survivors knew that they weren't alone, and that in Maryland they had a voice, and you, my colleagues, have come with me to do that. Our state does not need to be broken, and their voices do not need to be shunted. And I believe that this bill, as amended, does those things. And I ask for your support in finally allowing me to close this book so I can move forward. Thank you.
Thank you, Mr. Chair, and thank you, Mr. Chair, for bringing this bill. You mentioned 10 years. Wasn't there a time when you didn't bring the bill, and why?
Because I couldn't.
I'm sorry.
It's all right. Because it was so heavy. And I couldn't. And then I thought that we had won.
Wasn't there a pandemic, and wasn't everything by Zoom?
Yeah.
Yeah.
And there was that. But there's times when I just couldn't. And also, we thought we won, remember? And I say we because there's only a few of us. Boy. Thank you. But we thought we'd won, remember? And then there was some language snuck in that bastardized everything we did, and we had to go through this again. I spent this entire summer in panic mode because I was worried that the very law that we passed with my name on it was going to protect the Catholic Church forever, because that's what they argued to the Supreme Court. But there was the pandemic, so I definitely didn't do it then.
Yeah, I thought I remember a testimony that you didn't bring the bill because you didn't want the victims to have to testify at home alone.
Yeah, that's right.
Yeah, can you explain that just a little bit?
I just think that it's very hard to dig into this dark place, especially if you're recounting events. And it's very dangerous because most of these people don't have a lot of family. I've met one. I don't know these people behind me, but a lot of people I've met with, they don't have close family. And I was so worried because there's always a day when you're not going to make it to getting up. And I thought the most inhumane thing you could do is have somebody sit on camera and pour out their heart about their worst days and recounting those days to a screen with no tactile sounds, nothing more than just them almost amplifying their loneliness and their pain. So I felt it was better to hold off until we could all get back together and they could be heard by a group of people.
Thank you.
Delegate Eric Hand.
Thank you, Mr. Chair. Thank you very much, Delegate, for coming in and going through all of this again. I know how hard you worked. I watched 7 of the 10 years of it. So I've really looked through the reprint since it was sent over to me this morning, and I just want to give you a sort of opportunity to talk through why the tweaks you've made, in the last 24 hours or so are going to sort of take it out of the potential of having unconstitutional issues, because that was kind of my concern when I read the original draft. I thought, this feels a lot like the asbestos bill that I thought would end up getting caught up in court. So just share with us what the changes were that you made that you think have sort of alleviated that.
Well, I did have a letter from the AG. In fact,
Okay.
I know they're in negotiations. So the original, whichever, the last amendments were, by his opinion, deemed to be constitutional.
Okay.
Or that he could win, he believed. However, it just boiled down to, and as of last night, looking through and realizing that, number one, I didn't feel that it was a good route to go, and for the claimants that are already filed, even though 2 years ago they didn't have an expectation, they do now. I didn't have a problem with the occurrences because I think it's outstandingly zealous to think that each of those occurrences should be an $890,000 claim.
Okay.
And obviously fiscally irresponsible. And I wanted to make sure that the original or the amendments had a mandatory ADR, but there was no right to a jury trial. And I didn't write that.
Right.
And that's the last thing I wanted, someone with my name on truncating an individual's rights, if they so choose to go out and do it that way, to do it that way.
Okay.
So in trying to protect our state from financial, devastation, I did not want to break these individuals any more than has to be.
I know where your heart is on
Thank
this. Okay, so the process would be those that have already filed would still maintain the current cap that we had put in place. And they would still go through the new program?
Yes, and
Okay.
only because I just in case something settles, my worry was weird, but my worry was that it would just kind of go away, and we see it on TV all the time where there's an accusation and all of a sudden we call it hush money for the most part.
Right.
That's the opposite of what I wanted to do. So that's why it had to be retooled to make sure that that's not what it did.
Okay.
That there's no opportunity. There's opportunity for settlement, but it's got to be public. And then if they don't like that, they can still go to a jury trial, which it would indeed all be public and on the record.
Okay.
One way or another, making sure everything got on the record, which is why the ADR process is important.
Okay, so there's still an avenue for both groups, the before and the after the 30th, after the October, to end up in court should they so
That's correct.
choose to go that direction?
Yes.
Okay, all right, that makes me feel, a little bit better about it, because that was what I was most centrally worried about, is ultimately, would they still have access
Yes.
to the justice that they felt they needed?
And I'll be honest, Delegate, to my shortcoming, this is something I check out on so often, so I miss so much of that. When I dug my nose in, I was almost panicky, and thanked the chairman and everybody for when I really dug in, going, that's not at all what I meant, so to fix it, so yeah.
Yeah, okay, well, I appreciate your work on this, and hopefully, if there's any remaining issues, we can work on them as a team.
Thank you.
Delegate Carter.
Chair, thank you, Mr. Chairman, for bringing it in. I know how difficult this is. And I've heard this, your testimony for now years, and you've been consistent. This is not about the money. This is about recognition and responsibility and making sure that people are held accountable. I was concerned, and we talked about this quite a bit, about the constitutionality of what we're doing. Seems like we're okay, so we made the right choice, and I'm proud to have been part of that and supported it in the past. Question about well, this is not retroactive, but is the fact that you're treating people who file earlier versus later differently, is there going to be a constitutional issue with that?
There may be a challenge, but I don't think it's constitutional. I don't think your remedies are, I believe, and again, I'm not a constitutional lawyer, but your right to sue, when we set causes of action, those are protected. Remedies can be adjusted on the fly.
Okay.
So I don't believe there's a constitutional, especially because we're not doing it retroactively, which would have been DUA v. Comcast and all, very challenging. But
And
this
people
is,
will have notice, because this wouldn't go in effect in theory until September, so they would have
Correct.
notice so they could get it in before then and still,
That's correct.
still take advantage.
That's correct.
All right. And the second question, which is a little touchier, the fact that this is applying to state and not to the private causes of action. This is really also to maybe the opponents who might be listening as well,
Sure.
so they can. But if you look at the numbers, you might find that there are more children of color that might have been impacted by Department of Juvenile Services and other institutions in the state. And percentage-wise, there may have been far more people of majority of non-color, white, who might have been affected by the church or other institutions of private. Is this going to cause, this is not constitutional, but this is a question of the morality of it. I have no problem doing this because I think that what we're doing is we're creating a system where we may actually have the money to be able to provide what we can across the board. And it not being about the money, it's being about everybody's going to get their day in court. But do we want to be treating people of color perhaps not as
I'm going to have to
fairly?
stop you there, bud.
Okay,
Please do. Let me go ahead and explain. Number one,
go ahead.
I am a person of color, and I definitely don't need white folks speaking for me. Number two, and more importantly, to make it clear, I was a Boy Scout. I go to church. Most people around here go to church. Don't think that it doesn't happen in black churches neither. So I want to be very clear that this is going to affect people, period. To say that somehow people of color don't go to the Boy Scouts. In fact, there are people of color that are Catholic. So I want to make it very clear that is by no design that this is, and again, I know disparate treatment, disparate impact, but I'm not here to be focused in this on people of color. I mean,
And
so to be clear.
right, let me just, I'm not suggesting that. What I'm suggesting is we're treating people differently because of the institution from which they were impacted.
And that's very easy to explain because at the end of the day, each time somebody was molested, fondled, or touched, the state pays. We pay through DJS, arrest, jail time, counseling, school counseling, issues, the state. Every taxpayer, we pay for that and regardless. But the churches don't. They don't have to create any care systems. We do. Because you and I do, as attorneys, know a lot of the people that we deal with as defense attorneys, they were broken for a reason because somebody got to them first. And when the institutions do that, they are zero responsibility to take care of those people. And I want to be clear, when we talk about the state, we're not talking about the state. So the out-of-state attorneys may see this as a state, but it's not. It's us, the taxpayers, and what we can bear. And our burden has always been caring for those people. We set up systems to care for those people that these institutions abused. That's why we have a different price cap, because those institutions and those churches and those groups never pay like our taxpayers pay.
Okay, I mean, we can continue the conversation. It seems to me as if we're setting up a system where we are, while there's going to be a cap on just for but the abuses may have been very similar in how they were handled. And by the way, the way that it was handled by the private institutions may have, in terms of rectifying any problems may have happened over the years, is not necessarily accounted for in the structure and how these abuses are being compensated. I'm just kind of putting it out there that we may be creating an unequal system it's more unequal. I'm not, by the way, maybe I think that we should maybe cap everything because we want everybody to get some degree of compensation in order to try and make them as whole as we can without totally bankrupting or upsetting the entire fiscal accountability of all the institutions, whether public or private. And if it's not about the money, then maybe that's the way we do it. I want to have that conversation. We don't have to have it all here.
But to be very clear, taxpayers pay for every instance of abuse in schools, through arrest, through incarceration, and through treatment. Those institutions are never held to that accountability. So that's why there is a difference, and that's why the caps are different, because we realize that.
Okay, thank you.
Delegate Graham.
Thank you, Mr. Chair, and thanks for being here today. So the first question I have is, we had a bill a few years back. It was about asbestos, and it was about remaining claims. And a big part of the conflict in that bill was that we were taking the claims of people who had a right to trial, and we were forcing them into an alternative form of adjudication. And it looks to be here that the main premise of this bill is that any claim that's not already filed with the court is going to be forced into this program, which is not really defined at all. So I wanted, my biggest concern with the bill is there seems to be a constitutional question. So I wanted you to speak to how is it legal to force someone who has a legitimate claim into an arbitration, some kind of adjudication that isn't defined at all?
I believe that that's what this committee's for, is defining what the process is. It's not my committee.
Yeah,
I will also say that arbitration is not uncommon. You keep using the word, and that's exactly what it is. The only difference is this isn't binding arbitration. And what it does is so important. There may be individuals out there who don't really know, they have a timeline when they were locked up. They can't give much more. And you know, guess which attorney in this room is going to take that case? The answer is none. So for those attorneys, those victims who do have something to say and have a story, but don't have a strong claim, I want them to be able to go through a process too. And I want to make sure, and I think for our state's benefit, setting up this process is the only way that we're going to make sure that we get everyone's story. Otherwise, we have to rely on counsel. It's not my favorite thing to do because I am an attorney. I know the word, so for me, setting up the system and mandating is the only way that I know as a taxpayer, I get to know where my money went. Versus, again, settlements, which means it can all be done hush-hush, and maybe some important name or some big name gets swept under the rug. That's intolerable, and that's why it needs to be mandated. Everybody needs to go through it, because the only other way for us to expose these predators is that they all go to trial, and that's not feasible.
But this process does that as well. You could very well sweep these under the rug. There could be negotiations.
No, because there's a mandatory reporting for each dollar paid to each claimant.
That seems to be semi-private, at least under the bill. It all seems to be shielded.
You might have
under
the wrong amendments.
No, I have the most recent ones.
Okay, I don't know, but I will not be caught in you're trying to trap me. For the intent, regardless of what's written anywhere, the intent is that every dollar paid out for every claimant, it be made public.
Right.
They can redact their name, but that's the only thing that's private.
And I want to go ahead.
So if that's not the way it's understood, and this committee doesn't understand, it's not written that way, did my best, that's the intent.
Okay, and back to the question, how is it legal to force somebody into an extrajudicial process? That is the question for me.
I mean, and I'll be honest, Bud, God bless you when you come to my committee. Why would you think I would know that? I am not that kind of attorney. I can tell you what I know. I can tell you that I've gotten this from our DLS, and I'm assuming that it's legal. I know from the Attorney General's letter, which was much more prescriptive, that only allowed them to do an ADR process. That the AG's letter made it very legal, and it's literally a form of mediation before trial. If you ever get a divorce, they're going to make you go to mediation. You might not end up in mediation, but you're going to start there.
Right.
And that's all we want here, because that's the only way that I can be assured that their stories come out.
So we don't know the answer to that problem specifically. How many claims have been filed against the state?
4,500.
Okay. We were told back when we debated this bill that private and public institutions would generally be treated equally. How can we justify the state limiting its own liability while private institutions are indefinitely exposed and have much, much larger caps?
That's the question. I believe I answered that question.
Well, I just want to speak on behalf of the victims, because in a public institution, a detention center, you might not have an option to get out. You know, when we talk, I've read some of the stories of the victims. They're being detained against their will, maybe for a crime that's, you know, they're being detained in a legitimate fashion. These are people that are trapped, not only being detained, but being raped.
Yes, sir.
So when you compare that to someone against, you compare that to a situation where they're in a church, it's a little bit different. And it seems to me that in this case, the state seems to be the biggest offender here. And that's an issue
And
we
if you'd
discussed.
like to punish and bankrupt the state, God bless you, you can do that.
well,
If that's your goal, but it's not mine. Because like I said, we sat through a budget and I heard you on the floor. So if you want to go through that again on a larger scale with $17 billion, God bless you. But because we waived sovereign immunity as a state, we do have that right. And like as I've carried on before, because we do carry a lot of the burden just by being taxpayers, it's what you want to do with the taxpayer. I told you what I want to do. I don't have to explain any more than this. And I'm sorry to be this way. I'm not going to sit here and go back with you. If you don't like
that.
this and you want to go to the taxpayer, you screw them, because I'm not.
I respect that, but what I do want to do is what I always do in this committee, and what we don't frequently do, is talk about the victim. And
Holy shit. You know what?
These people have lived through some.
Who are you talking to?
No.
Do you really think for a minute that I don't know? Do you think I don't know what the victims go through? And do you think there's any amount of money that's going to make it better? Because you can lie to yourself, but it's not.
Mr.
It
Chairman.
changed.
Mr. Chairman. Mr. Chairman. Mr. Chairman, thank you. Delegate Simpson.
Give the chair a moment. Chair, thank you very much for bringing this bill. Would you consider so my understanding of the bill is obviously limiting the liability, because obviously the state does not have an unlimited pool of money. But we also want to make sure that we are acknowledging what has happened, and that we also want to make sure that we are gathering the data. Is that correct?
Correct.
Okay. Would you consider, instead of them having to redact their name, that their name is automatically redacted, unless, of course, they actually want to be?
Of course. I trust this committee, even the people I might argue with, to make the best choices, period.
Okay. Thank you.
Thank you, Mr. Chair, and thank you, Mr. Chair. I wasn't here 10 years ago. I was here 3 years ago. And the thing that sticks in my mind has always been, out of all of the hearings that I've participated in, it was that first one, the first year, and then the second year. I admire you immensely. So now let me get to my question so my chair doesn't get upset with me. I know it's not about the money. And you've given us a bill that I think we're going to have to figure out some of the additional details, and Delegate Simpson just brought one. Another one is, while it's not about the money, I want to make sure that the victims get as much as possible. In the state of California, in their ADR process, they limit attorneys to 20% under ADR. They then do 33% if there's litigation, and 40% if it actually goes to litigation. Would you be amenable if we looked at something like that to ensure that the victims get as much as possible?
Without a doubt. Again, I think I thought under the Maryland Tort Claims Act, they could only get 20%. So I just presumed this fell under that, but if it doesn't, I would be very pleased if we would. Thank you.
The other piece in setting up the process, as Delegate Grammer said, had you thought about and giving us some guidance on where we might suggest that go? within state government? Like, who should do that? Should it be the courts, or are you going to leave that to us?
And again, but that's a tough one. And I've talked with, I just have, and I know I'm dropping it on you guys in a short amount of time. I just have to trust y'all because I've thought through it. There's a few good ideas, but none great. So I think that's something I would leave to Mr. Chair and the members of this committee.
And you mentioned the State Tort Claims Act. I mean, at the end of the day, we've gone above and beyond to date because in my mind, all of these things are tragic, but we've limited our exposure on everything else to $400,000.
Correct.
So would you say this is fair?
I believe this is a very fair approach.
Once again, thank you, Mr. Chair.
Thank you.
Appreciate you.
Mr. Chair, I apologize for my outburst. This is a very sensitive topic to me, and so I do apologize, sir.
I understand. Thank you very much for coming and testifying today. Those are all the questions from the committee, it appears. Thank you very much. Going to go to a panel of people who are favorable with amendment. Lisa Jordan and Rebecca Snyder.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. I'm an attorney, and I'm here in support of House Bill 1378, favorable with amendments. The reason that the Maryland Coalition Against Sexual Assault supports a bill to amend the Child Victims Act is because we represent all survivors. Make no mistake, we firmly support access to civil justice. I have fought for it since at least 2003. Long before it was big business in Maryland. But we also recognize that if changes are not made, there are going to be cuts to victim services, there's going to be cuts to prevention, to health care, to other important functions of government that survivors and Marylanders rely upon. There's simply not enough money. The law does need to change. The amendments before you are so much better than what I saw on Monday when I filed my written testimony for the second time. I think you have me in there twice. I am going to ask that the committee consider a couple of things. I would ask that you consider taking responsibility to choose the state entity to conduct decision-making. That is something the General Assembly should have the responsibility to figure out in the light of day with a debate. The Maryland Coalition Against Sexual Assault believes that arbitration is not necessarily a bad option, and we support options for survivors. My colleague, my counterpart up in New Hampshire, they do that up there, and we talked about it. I will say they also allow survivors to choose a jury trial instead of just appealing, and that's something that you might want to consider. Finally, I just want to say that reducing recovery to $400,000 per claimant is really troubling. That's going to reduce the state's incentive to protect a child once they've been abused by the state once, because the second time is not going to be more expensive. At very least, please consider a claim per abuser. I'll also thank Delegate Phillips for the comments on attorney's fees. We should help survivors. We should help survivors. If you can take these cases out of court and mandate that they go to ADR, you can also delay your decision till the next time you're in session. So I will also say,
I need you to begin to wrap up, please.
Please take the time to do this right. We've seen what happens when you don't. Thank you.
Thank you, Ms. Jordan. Snyder, please.
Good afternoon, Chair and members of the committee. My name is Rebecca Snyder. I'm the Executive Director of the Maryland, Delaware, D.C. Press Association. And our amendments, it's not a concern. We're here simply because we want to ensure, and I know the amendments are evolving and so forth, and the intent is there, but we really need transparency in this process. The sort of spongy, unformed state entity that would be handling ADR That needs to be a transparent process. I was really heartened to hear Chair Wilson talk about the transparency of the settlements, but I'm sitting here before you to just make sure that it is an open and transparent process as you deliberate. I recognize that these are very sensitive issues, and we want to make sure that they don't we don't obfuscate by shielding them in secrecy. So thank you for considering those amendments, and if we can help in any way to foster that transparency, we're happy to do so. Thank you.
Thank you, Mr. Chair. Thank you both for being here. My question's for Ms. Jordan. I just want to make sure I cover what tweaks that you were still hoping for, given the new language. So you had mentioned that you want to make sure that it's not per claimant, but per perpetrator. So I guess the scenario would be sort of if someone was like a DJS and two people in a position of authority had abused one child, that person would get both days in court. So they would have an opportunity. Okay. So that seems like a small fix that could be attained. And then you said you wanted to make sure that we sort of chose where this was actually, because it's very amorphous in the bill right now. It's like the governor will figure it out. I also didn't love that piece. That's super uncomfortable. Did you have any suggestions on where we might try to nestle something like this? Any?
It is a very difficult issue because, of course, the state is the defendant. Certainly the courts are an obvious place. I believe that's what they're doing in New Hampshire. You could also create a quasi-judicial entity similar to the Judicial Disabilities Commission or that sort of entity, but you need to have an entity that is free from conflict, and it's the state being sued.
Right.
And I am very concerned with this idea that the defendant is choosing and creating its own system without the oversight of the General Assembly.
Okay, yeah, so I was thinking of maybe ALJs, that that process also has a bit of conflict pre-existing in it, in that they're often representatives of the actual departments, and then they're also adjudicating claims against the departments. So we don't want to sort of recreate that system again, because I think it's already a little odd to begin with. So maybe we can come up with some kind of alternative, because I agree, I don't feel good about asking the very person who's responsible for the budget at the end of the day to try and not limit his exposure to the cost of this.
Thank you.
Are there further questions for this panel? Seeing none, thank you very much. We're going to hear from now 3 panels of unfavorable witnesses, beginning with Patrick Thronson, Kara O'Brien, Ellen Flynn, John Doe, and Joshua Kahn. We will be starting from the seat on my right, your left, and moving across. Everybody's going to get 2 minutes.
Mr. Chair, if I may, Mr. Kahn had to leave. My name is John Wilbert. I'm signed up as well. Okay.
Okay.
Thank you.
One other person.
Apologize.
Starting from my right, your left, and then moving across. Sir, please, for 2 minutes.
Good afternoon, Mr. Chairman, Madam Vice Chair, and members of the committee. Patrick Thronson on behalf of the Maryland Association for Justice and my clients. We respectfully urge an unfavorable report on HB 1378, recognizing the heroic efforts of Delegate Wilson and other members of this committee in passing the 2023 CVA. HB 1378 would retroactively and prospectively impose unreasonable restrictions on the right of access to the courts for survivors of child sexual abuse. And it would retroactively and prospectively slash the applicable damages cap to $400,000, just 1/4 of the cap that applies to private institutions. In our view, the bill likely would violate the Maryland Constitution. Under Article 19 of the Maryland Declaration of Rights, child sexual abuse survivors have the right to bring their claims against the state within a reasonable period of time and vindicate them before a jury without first going through an unreasonable, re-traumatizing process established by the defendant, the perpetrator. Under Article 24 of the Maryland Declaration of Rights and Article 3 of the Maryland Constitution, They also have a vested right to recover all damages against the state that are permitted in the 2023 CVA. That is the $890,000 figure per claim. These rights are vested property rights as of the effective date of the CVA. As the Maryland Supreme Court held in Dua versus Comcast Cable, no matter how rational under particular circumstances, the state is constitutionally precluded from abolishing a vested property right. And under PG County versus Longton, this court held that damages caps cannot be retroactively abolished. The court held, although the legislature may in its wisdom limit tort damages prospectively, the Constitution protects against retroactive application of these limitations. In what other area of law do we force an injured party to go through a claims process set up by the defendant? We believe that this committee should honor its commitment to survivors as established in the 2023 CVA. We believe it should have its yes there and yes now, and we urge an unfavorable report. Thank you.
Please.
Thank you, Mr. Chair, Madam Vice Chair, and members of this distinguished Judiciary Committee. My name is Kara O'Brien. I'm here today on behalf of the Maryland Association for Justice and the Yost Legal Group, where I represent survivors of sexual abuse in the juvenile detention centers. I really do want to thank Chairman Wilson, this committee, and our entire legislature for the wonderful work that was done that culminated in the Child Victims Act of 2023. I've had a chance to speak with so many survivors that are so genuinely grateful for the opportunity to have access to our civil justice system after all these years. I acknowledge and I respect that this is a very difficult situation, but I know that we can work together to find a fair and just solution. So over the past year, I personally have interviewed over 100 survivors of sexual abuse at juvenile detention centers. For many of those survivors, I was the first person they told about their abuse. They had the courage to come to us, and they had the hope under the CVA that they would get justice for what happened to them. My hope here today is that their voices can be heard through me. This is not about me, it's about them. This whole room is full of them. I don't think they can stand up, but they could raise their hands and show that they're here. And I think, okay, and it's important. So moving forward, I appreciate the Second Amendment to this bill, but I think it's important that we keep some common themes in mind. All they want is accountability, justice, transparency, and no further delays. I believe this amendment to this bill would cause further delays. Since the CVA has been passed, it was wonderful, but my clients have told me they can't sleep, they can't concentrate, their relationships and their jobs have suffered, and they really do need resources to help them and their children. My clients have broken bones and physical scars from what happened to them. They have depression, anxiety, and PTSD. We have a chance to help them heal in a healthy way, and it's unique for everyone. My clients wrote some really beautiful words I don't have time to get to, but I know they know that the state will do the right thing. So thank you.
Good afternoon, Mr. Chairman, Madam Vice Chair and the committee. I am Ellen Flynn. I'm an attorney, former past president of the Maryland Association of Justice, and an attorney at the Yost Legal Group. I have interviewed as well hundreds of childhood sexual abuse survivors. This important work has opened my eyes to the population of citizens of Maryland who have suffered immeasurable losses and whose lives have been derailed. These people need access to Maryland's full justice system. The 2023 CVA was an important step towards justice for the most vulnerable in Maryland, the children of Maryland who have been subject to abuse, and navigated the wake of this abuse on their own. To be clear, these citizens still face significant hurdles to prove their case even under the 2023 CVA, to muster the bravery to come forward, to file their claims, and to disclose their injuries. They still have burdens of proof, often hampered by the young age in which they were abused. They have to identify abusers and dates and locations. Denying them access to the full civil justice system, including discovery, would hamper their abilities to prove their claims. Eliminating access to justice and placing a $400,000 cap on these claims will needlessly eliminate justice for those who need it in Maryland. I would like to tell you about one case where the Maryland Department of Human Services failed to screen and supervise the placement of children with a foster parent named Samuel Glover. I have submitted foster parent Samuel Glover's guilty plea hearing transcript and the statement of facts in support of the guilty plea to the committee today so that they can consider the weight of these facts for yourselves and consider changing the justice afforded by, not changing the justice afforded by the 2023 CVA. The Attorney General's office is arguing in that case that the subjects of abuse are not entitled to bring their claim because they do not owe a duty to the foster care survivors of abuse. 3 children were abused in that foster home, and the facts are horrendous. I would ask you to review them. They have been submitted to this committee.
Thank you. Sir, if you wouldn't mind pulling the microphone so it's in front of you so that you can speak into the microphone. Please go ahead.
My name is Hakeem Ahmed, not John Doe. I was a victim at the Maryland Training School for Boys. I was raped, sodomized by staff there. I'm not seeking money. It's not enough money. I need therapy. I don't trust people. I'm angry. I'm mad. I felt guilty, ashamed of what happened to me. And Maryland Training School administration turned a blind eye to this. And they knew it was happening at this time. And I'm seeking justice. I need therapy. I'm angry. Some people might want money. That's all good, but it ain't enough money. You can't buy me what happened to me up there. And the man did this to me, cost me a lot of pain. I mean a lot of pain. I mean a lot of pain. I don't trust nobody around my kids. No, I don't trust nobody on my job. What happened to me? Yeah, they did me wrong. Yeah, they did me wrong. And it ain't about color. It's about what happened to me. At 2400 Club Hill Road, what they changed it to John Hickey School. Yeah, it happened to me. I'm not ashamed no more to come forward, and I hope more people come forward, because this was going on up there at that time. I have no more to say.
Thank you, bro. Thank you. Mr. Chairman, I'm Andrew Freeman, I'm an attorney at Brown, Goldstein, and Levy in Baltimore, where I've been representing victims of child abuse for over 25 years. I've seen what the abuse does to them. $890,000, the current cap, is inadequate. To slash that to 400 is more than inadequate. It's insulting. It also is retroactive to the extent that we're taking away the expectations that people have built based on the CVA that you all passed 2 years ago. I'd suggest, members of the committee, that this bill, this amendment, would not save the state very much money. It leaves open the door exactly as we have the current law, which is a good thing, through September. It then closes it only for people who come forward October 1st or later, or very much narrows it. There are a number of problems with the bill that you'll hear from other speakers, but if we wanted to do it prospectively, it would be for people who are abused after October 1st, not people who come forward after October 1st. Part of what was so admirable about this bill, the CVA, when it passed, was that it recognized how hard it is and how long it takes for so many victims to come forward. And all this bill, this amendment would do is say, if you're courageous enough, if you're ready enough, if you're psychologically prepared enough to come forward by the end of September of 2025, you would get $890,000. If you're not ready, we're going to do, you're going to have your possible recovery cut by more than half. I would suggest, just as a last point, that there are all sorts of confusing aspects with respect to what this arbitration, so-called arbitration, would be. Chairman Wilson referred to it as mediation, as arbitration, as voluntary, as not, was unclear about what the circuit court would look. I would suggest that it would be appropriate to have summer study and get it right rather than rush it through at the last minute.
Thank you. Delegate Arakan.
Thank you, Mr. Chair. Thank you all for being here. Actually, I do recognize a lot of your faces. So thanks for coming back. I know this is hard, and thank you, sir, for being so brave and speaking for yourself, but also for a lot of other folks who can't come forward yet and may never be able to. I don't know if you guys had the opportunity to hear Ms. Jordan and express some of her concerns. I'm going to try and just get maybe Ellen, if you want to just like come in, or anybody else, just say what you think about a potential tweaks to the system. If we were to still come up with some kind of arbitration process, she'd mentioned New Hampshire, where you can kind of choose if you'd prefer jury or arbitration. How would you guys feel about a system that allowed for the victims to choose which path to take?
I think one important aspect of the access to justice is the access to discovery.
Yeah, that was my next question.
Particularly important with respect to the child victims, because they don't, several of our clients have been abused at ages as low as 5, 6, 7 years old. We need access to documents and to their history in order to prove their claim, or it will just be denied. And they will have come forward with their story only for them to be shut down yet again.
Okay.
And that would be very, very problematic.
Okay, so if we did some kind of arbitration, made it optional, but required there to be full discovery so that you could even try to prove it, because I see there's no way you could prove any of it in an arbitration process without discovery. That would be impossible, so they would really never get their day.
Correct. I also think it's very important for many of these survivors to have access to the ability to cross-examine.
Yeah.
Right? And to be able to hold those accountable through the judicial system, perhaps a public judicial system. It's not just their story that they want to tell, it's the violations of their rights that have occurred, or the breaches of the duties that have occurred that the state had control over and had the responsibility to them under. And that is really important for the whole public to see.
Okay, so if you could pick a place where we could nestle something like this, if you could imagine it, where, if you had to design it, where do you think it would most be appropriate to put something like this? How can we make sure that the very people that we're suing are not the ones that are deciding how much they want to be sued?
Well, that is a significant issue.
Yeah.
I'm sure that I'm the best to answer that, but I think full access to justice is important. I think it is a judicial process that should be available to all.
Okay, so ideally it would be in the judiciary somewhere. We would find a way to create a sort of, she mentioned judicial disability type commission. Would that match with any type of, I see, he's like, eh.
I'm not a judicial, I'm not familiar with that. So
Okay.
That's not something I've practiced in.
I would just say that we're here on March 25th, is that what today is?
Yeah.
And 26th, there are just so many problems and so many ambiguities with this amendment. Summer study might be appropriate to try to figure out how, well, what's mandatory, what's not. I have no idea what this amendment does. It says that there's an appeal to the circuit court. Is that de novo? Is that some other standard?
I believe it's de novo.
It's just not clear
Okay.
in the current bill. There's a lot of work that this needs, and your very good question should be addressed more thoughtfully than based on a bill that we saw this morning for the first time.
I understand. We got less time to read the budget. I'll just throw it out there. But I really appreciate you, and I appreciate all the victims that have come forward. We know how horrible this is to come forward, because we hear from you all the time, and we are so sorry that you are having to come again. We are so sorry.
To the panelists in the middle, what's wrong with the $890,000 if you file today versus if you wait 6 months now? You make the choice to wait 6 months now, and it's capped at the $400,000.
I think if you're directing that to me.
Yes.
I think what this committee recognized in 2023 is that victims of childhood abuse have a very difficult time coming forward, even after all of the advertising that has been on, asking victims, particularly in the Catholic Church, to come forward and to get help. But it is still very difficult for them to do that.
Sure, I was on this panel, so I understand that. So I thank you very much.
Yes, Mr. Chair, and I have two, but they will be brief if that's all right. And if only one person could answer, that'd be great, because we have a lot of senators waiting. My question is, you heard the chairman earlier in his testimony saying that he was doing this not out of pleasure, but to not bankrupt the state. So it's relatively easy to oppose a bill, but I was wondering if you had any cost, you don't like this cost containment measure, so what's your alternative? And my second point is, my dear friend Delegate Phillips was talking about how, I think it's ADR, he said, how California limits it, how other states limit it, and would that be an appropriate cost containment for the proposal for the lawyers at the table? Because of course, I sympathize with your clients, but my grandfather was an accountant, so what's your alternative?
If I could speak to that in part, there's a letter in the record from an attorney that summarizes some of the discussions that have been had with respect to settlement. And what's disclosed in the letter is that the discussions are far from, or have been far from the $2 billion or $4 billion figure that's been floated. I think unfortunately in the current climate, this bill is raised in part out of fear for the financial future of our state. But I think there really needs to be attention to the facts and to the specific amounts that are being disclosed. And so I think in the absence of having that data, it's not appropriate to limit severely the rights of severely injured people in the state, both going forward and retrospectively.
Answer the second question, which is would ADRs be limiting ADRs be an appropriate alternative for you guys?
Would ADR be an appropriate alternative?
Would limiting ADRs, like my friend Delegate Phillips was talking about, be an appropriate alternative?
Attorney's fees.
Oh, sure. Limiting attorney's fees. I mean, attorney's fees are already capped under the State Tort Claims Act. So we have to be careful with attorney's fees that we both respect the right of people to make contracts with each other, and also to give an appropriate incentive for people to pursue these extremely difficult cases to make sure that survivors achieve justice.
Thank you, Mr. Chair.
Vice Chair.
Thank you, Mr. Chair. For anyone, I think the two ladies, I'm sorry, I didn't write down your names. But if just one of you could answer, what is the burden of proof or persuasion with respect to ADR?
That's a good question.
Or whoever knows the answer to that question.
Well, I think that would be defined by the ADR process, but I don't know that the burden is any different under ADR than it is under a full justice system.
Well, that was going to be my next question. So in a civil trial, what would be the burden of proof? Can you move the mic closer to you if you're going to answer?
Do you want to answer?
Go ahead.
No, it's more likely than not. It's a preponderance of the evidence.
Okay, and so I heard someone mention that in a civil trial, you get discovery, in ADR, you would not.
It depends on the rules of the ADR, Madam Vice Chairman.
I just wanted to make sure that was clear, that you could have discovery in ADR.
So the problem is that it's not clear under this amendment.
No, I got that, I get that. I just want to make sure we know as a committee, so that when we go back and work on it, we are clear. And so the cost of ADR versus trial, which one costs more?
It can be the same. Again, it just depends on how the system is set up. It can be the same.
So we could put limitations on the cost of trial and the cost of ADR as a body? Is that what you're saying?
No, so it has to do with what process we have to go through in order to get across the finish line. As the amendment's currently written, you can go all the way through ADR and then apparently could do it a second time in court. It would actually add a layer and add expense. So voluntary ADR or voluntary mediation, I think we would all support. But when Chair Wilson said, he was doing this to help people who didn't have the resources to go through court, have confidence in the survivors that they know what's best for them. If they want to go to court, you should allow them to go to court.
I think we did talk about voluntary a little bit here. So what was the age limit prior to bringing a claim, but prior to the 2023 Child Victims Act?
38.
And what is the age limit post the 2023 Child Victims Act?
There's no age limit.
No age limit.
Okay, so there was so the Child Victim Act really put people in a position where they can even get anything, because there wouldn't have been any recovery for someone who was 39, 40, 41. Is that correct?
That's correct. And so as of today, no matter how long ago they were abused, they can get up to the current cap, the 890 per occurrence cap.
Right, and do we have any other type of law that allows an individual to make a civil claim, no matter what age, or no matter what time it occurred?
I think that was what was wonderful about the Child Victims Act, Madam Vice Chair, is that you all recognized the conundrum that Ms. Flynn talked to, that the median age that people disclose is 52. I have clients who are coming forward for the first time in their 70s. Literally, I got a call last week from somebody who had never told anyone of his abuse until he called us, and he's 72 or 73 years old. Fortunately, and we're grateful to Chair Wilson, we're grateful to all of you, he now has an opportunity to get some justice for what happened to him years ago.
Right, and so I guess that's part of my concern. I'm hearing that this bill, even as amended, does not help victims or put them in a better place. They would not have received anything prior to the 2023 Child Victims Act. And I want to make sure that part is clear. Is that correct?
That is correct.
Okay.
And what we're trying to avoid is what you gave, as Mr. Sharkey said, we think it would be unconstitutional to then take away.
Even if it would bankrupt or at least cause some degree of burden to the taxpayers?
So yes, it would be unconstitutional no matter what it costs taxpayers. Number two, as Mr. Sharkey said, we don't think there are ways that this would not bankrupt the taxpayers.
Okay.
This can be, and number three, I as a taxpayer locked these folks up and failed to care for them and put them in this situation. I am, as a taxpayer, am responsible for some sort of fair compensation to them. Is that going to cost money? Yes. Is that going to bankrupt the state? No.
Gotcha. I had one more question. I forgot what it was because I didn't write it down, as my chair always advises. Sorry. It's your fault.
Thank you, Chair. One of the points that Chair Wilson made, and one of his motivations, was the idea that if there are settlements, they could be completely outside of the public eye and the perpetrator would never be known. I thought that was a really interesting point, and I just wondered if you could comment on that.
Yeah, I think it's just not true. The state, I'm not aware of the state being able to settle anything confidentially. When the state makes a settlement with public dollars, that's public information. The larger settlements all have to go before the Board of Public Works. But any settlement, I'm not aware of any confidential that the state has an ability to settle anything confidentially, and I don't think it should. That we do already have the opportunity to file anonymously for our clients, for those of our clients who want to preserve their identity. But otherwise, everything's public.
Seeing no further questions for this panel, we thank you very much. Kenneth Gardner, Kagan Johns, Corey Stern, Antoine Harris, Alexis Massey.
Mr. Chair, my name is Frank Mattel. Ms. Massey has advised me that she had car trouble and cannot make it, so we need to strike her.
I'm sorry?
Ms. Massey has advised me that she had car trouble and is not able to make it, so we need to strike her from the witness list.
Thank you very much.
Thank you.
I see two people. Are you one of the people I called?
No.
I am. Okay, that's fine. So we'll hear from the two people in the middle and we'll go from there. Sir?
Good afternoon. My name is Corey Stern. I'm an attorney at Levy Koenigsberg. Chairman, Madam Vice Chair, thank you for allowing me to be here today. I don't see Chairman Wilson here, but I genuinely want to thank him for his support of and fight for and passage of the Child Victims Act. Regardless of what he might think, we think of him, and regardless of what he might think of us, the reality is we need more Chairman Wilsons than less because of the passion that he brings and because of his own experience. What I have never shared with many of my colleagues and only the people closest with me, even though I'm one of the out-of-state lawyers that he referenced, is that I too am a survivor. And 20 years ago, I filed my first case for an individual who had been sexually abused at a juvenile detention center in Georgia. 10 years ago, I was fighting for legislation across the United States, and in particular in New York, for survivors of sexual abuse. And just because my driver's license says Georgia, and just because my residence for work is in New York, doesn't change how deeply I care about this issue, as does Chairman Wilson. There's been a number of conversations thus far about the constitutionality of this amendment. I don't want to belabor some of the points that were made, but what I would like to say is that it is very, very clear, extremely clear, that under Article 17 of the Declaration of Rights, you cannot impair a right that you have already conferred on a resident or someone within the state of Maryland. The day Governor Moore signed into law the CVA, rights were conferred on anyone who had ever been abused prior to that day. You could change the number to 400,000 and that would be unconstitutional, but you would still be taking away a right. You could try and do away with the entire statute, but you would then be taking away rights that you all conferred. Nobody wants to bankrupt the state. Nobody's trying to bankrupt the state. But instead of blaming all of the individuals who you see out here today who you've never seen before, the reality is what's baked into the statute has conferred rights, and we'd rather you work with us to try and find a solution than to force one at the last hour.
Thank you. I believe Mr. Harris.
Good evening, ladies and gentlemen of the committee. My name is Antoine Harris. I am the survivor and also the descendant of an abuse survivor. My mother was incarcerated at Montrose, and my father, my biological father, was an employee there who is still alive. My mother has since passed. I was also abused at that same facility and at training school. I've been to every juvenile detention center in the state of Maryland. Because of my mother's situation, she had to run away from Montrose when she was pregnant with me after she had been impregnated by a member of the staff. She had to run away in order to deliver me because they were trying to murder me while she was pregnant with me. And I was a ward of the state, a Senate child from 7 months up until 21. And I was abused 5 different times under state agencies, 3-letter agencies, right? DJS is just one of them, right? DSS is another, right? And so right now we're talking about DJS, and that's 2 different individuals there that abused me multiple times. All I can say is that no amount of money, and again, thank you to the chairman that spoke earlier, who said that no amount of money could ever make it right. But the reality is that individuals, and I haven't read the current amendments or to the CVA, but I would say that the equal justice under the law is appropriate for any victim, no matter who the offender is, whether it's the state or a private agency or an individual. I thought that was guaranteed under the Constitution. I would love to take questions.
Questions for the panel?
No questions?
Delegate Grammer.
Sure.
Sorry, for the first gentleman, I missed your name.
Don't be sorry, most people forget it. It's Corey Stern.
Corey, can you just touch briefly on the constitutionality questions? I'm not as concerned with the damage amount, but the scope of the constitutionality issues in the bill, in your opinion.
So they're tremendous, and whether we like it or not, I believe Madam Vice Chair had asked earlier, I don't know who's who, but I believe it's Vice Chair Bartlett had asked earlier about ADR versus a jury trial. The reality is we have a system of laws that some are good, some are bad. Some people believe in the Second Amendment to the United States Constitution, others don't. There was a committee meeting that I heard about outside today that dealt with guns and trafficking from southern states, hopefully not the one where I spend most of my time. The truth is that every American and every Marylander is entitled to a jury trial. That's just a guaranteed right. And you can't just, because of the financial consequences of a piece of legislation that may have passed, which subsequently come to mind that suddenly we've done something that might negatively affect the state or might negatively affect our ability to create a balanced budget. The reality is that is a guarantee, both under the United States Constitution and in Maryland. And so if there's a voluntary process, a voluntary mediation process, a voluntary arbitration process, perhaps that would be constitutional. But the reality is you cannot deprive a citizen of their constitutional rights. With regard to the fact that this legislation, as this gentleman said, would treat people disparately, differently, it certainly would deny, under the current amendment, a full remedy to victims of governmental inflicted child sexual abuse, because it on its face treats people disparately differently, not just from the $890,000 number that is currently in the newest amendment to the $400,000 that would occur after September 30th, but from the first bill that was passed. And so in the first bill, like it or not, it says per occurrence. In the new bill, it says per claimant. That is disparate treatment between a claimant who, under the previous bill or under the current bill, would be entitled to per claim. And then finally, under well-settled Maryland law, and it's for lawyers that do what we do, unfortunately for the state, it's probably the strongest law in the country on a state-by-state basis about accrued rights, about accrued causes of actions for rights that have been granted. You all, through the passage of the Child Victims Act in 2023, created a vested right in individuals who had been sexually abused before that time. And to change that now is to take away a right that was accrued. That doesn't solve your problem. It doesn't mean that, well, damn be the budget, everybody's going to go bankrupt. It just means that rather than trying to create a fix through an amendment legislatively, try and sit down with, not all of us are bad. Like many of us have been meeting without disclosing too much with members of the Attorney General's office for over 2 years, and the stories and the numbers that are coming out in the press are ridiculous compared to what's actually been discussed. And I admire C.T. Wilson. I wish I had the courage to run for office and to do the things that he's done. At the same time, some of what he said is not accurate. There's 1,500 cases that have been filed in the civil courts in Maryland. Not 4,000, not 5,500, not 6,000. There have been ongoing negotiations where the numbers pale in comparison to those that have been expressed here. And you have my word, whether that means anything to you or not, but the fact that I got up here and told you one of my truths that I've never shared publicly should give you faith that if your government wants to sit down with the lawyers who represent these people and do the right thing, we are ready, willing, and able.
One final question, if I may briefly. So I think you probably have the answer to this question, and I think as we debate this bill now or next year or whenever, it's going to come down to the right to jury trial. That's really when we've debated similar but different bills, that's what it's really come down to, is that bill seemed to force people into binding arbitration. This bill seems to force these claimants into whatever you want to call it, whether it's arbitration or not. To me, that seems like a bit of a constitutional issue. Can you really just go at that for me, please?
It's beyond a bit of a constitutional issue. It's one of the most fundamental, it is a fundamental right that all of us as citizens have, is a right to a trial by jury. And there is no way to legislate. If we're going to do that, we may as well light the Constitution on fire. I'm deadly serious. And it doesn't mean it's the best system in the country. It doesn't mean that it's going to save taxpayers money. But when the founders created the Constitution and the Bill of Rights, one that they conferred on all of us is the right to a trial by jury. We learn about it in law school. We learn about it in government. We learn about it in ethics and history as we're all kids. We all know it. And the solution to a budgetary problem is not to take away fundamental rights. It's to find a way to use what's been guaranteed to the people in a manner that both suits what the government is trying to do, which by all accounts is the right thing. Nobody passed this bill because they were trying to hurt victims. Everybody passed this bill because they were trying to do the right thing. Is it anybody's fault that they could not foresee how many claims there would be? Of course not. Is it anybody's fault that the budget currently is what it is in Maryland? Of course not. So how do you bring these two things together? It's not by denying the right to a jury trial. It's by sitting down with the very people who may feel like adversaries, but who have the exact same mission as the ones that y'all had when you passed the bill. And that is to make it right by everyone, for everyone, without bankrupting the very people who are paying that bill.
Thank you.
Vice Chair.
We talked about right to trial by jury. I just want to give you an opportunity to correct the record. The right to trial by jury, do you mean only in criminal cases? And do you mean only in federal cases? Because that's where it's stated in the Constitution. I just want to make sure we get that correct.
No, ma'am, I do not mean that. It is in civil cases you are entitled, every American citizen is entitled to a right to a trial by jury.
For every single case?
Every single case.
Okay, well, that's something new to me. I've never heard of that. I've only heard of the 6th and 7th Amendment, and I never knew that. So thank you for letting me know that. So with respect to non-economic damages cap, I'm going to go there for 1 second, Mr. Chair, your head, I hope it won't roll around. Is there a cap in cases in the state of Maryland where we have said you can only award X amount of dollars in the state of Maryland as well as in other states?
Yes, ma'am. If I just want to correct myself on your last question. The guaranteed right to a trial by jury for Maryland citizens is contained in Article 5A and 20 of the Maryland Declaration of Rights.
Okay, thank you.
You're welcome. With regard to your question about, I'm not your adversary, and so I was getting a little flustered because I'm not trying to be confrontational with you. With regard to your question about caps, yes. I mean, there's caps on damages under the Maryland Tort Claims Act in the same way that there are caps in many states and many places on various causes of action. It also normally requires a higher level of activity on the part of the claimant before even being able to bring suit. So there's no issue under the current Child Victims Act as to the constitutionality because it applies equally on the whole, to victims of sexual abuse. I understand that there's a higher amount of money for folks who are not abused by the state, in the same way that someone who's run over by a truck that's privately owned is probably entitled to more money than they would be if that truck was a state-owned truck, hence the Maryland Tort Claims Act. So the answer to your question is yes, and the current bill as it stands, not the amendments, but the current bill as it stands is in fact constitutional.
Okay, I just wanted to make sure we got there because I was hearing a couple other things on that, and I just want to make sure we got there. Thank you.
Thank you.
Sir, thank you very much for coming and telling your story. I really do appreciate it. I know it takes a lot of bravery, and it took a lot of time for you to get to this point.
Yes, ma'am. I'm sorry, go ahead.
And yeah, we have to ask a question or we get thrown off.
Yeah.
And I like it here. So
Speak for yourself.
I know.
I know that, folks come up and say this isn't about money, and the bill really is not supposed to be about money. It's supposed to be about acknowledging a wrong and taking responsibility. And you said it's not about that, and I know the other gentleman gave some indication of what they would like to see, which is therapy. So how would you, realizing this is something that the state has done, what would you be looking for?
Honestly, and this is not my first time suing government.
Okay.
Okay, and all I want is accountability from government. Bring out the records, show what they know when and how, right? I mean, that's the bare minimum that I think should be expected, because they know who some of these abusers were and they didn't fire them.
Right, as a survivor,
Right.
you want
and they didn't
to
fire
prevent it.
them, and they didn't do anything. That's what I want. That's more important. The Maryland State Archives is around here, right? They got the records. just like the gentleman who happens to be my biological father, who happens to still be alive, and my mother is dead, he changed his name legally in the state of Maryland. And, you know, the state covered it up. They knew she was pregnant. When they saw me, they knew who my father was.
Okay.
You know, so again, the state has been covering up abuse of victims for many years, right? I can only go back in my time and my mother from my birth, but I'm sure it's continued longer.
So to be clear, you want the state, which is
turn over
reasonable,
all-
to do an investigate, to truly investigate
what happened.
and reveal, not
Yeah.
necessarily your name or
Everybody-
other victims'
yeah,
names, but to reveal
the abusers and the information.
where, when,
why, and how.
and to the extent, I mean, I'm thinking of like the Sandusky, you know, to what extent others knew and
yeah.
hold accountable.
Yeah, exactly.
Not simply the abuser.
Yeah, exactly, because there's definitely people that were aware of these things and allowed them to continue, whether they were abusers, whether they were voyeurs, or whatever they might have been, or just participants, or whatever they were. You know, systemic abuse doesn't happen by chance.
Thank you.
Ma'am, may I just provide one?
Delegate Phillips. Delegate Phillips.
Thank you, Mr. Chair. One component of this bill is ADR, Alternative Dispute Resolution. And my sense is that you all may have some, you articulated you have some issue if it's mandatory and that's the only thing, and then you would have to go to trial if you appeal. The courts could today say that you have to go to alternative dispute resolution, correct?
The courts could today mandate that you attend and participate in good faith in alternative dispute resolution, but the court cannot mandate that whatever occurs in that proceeding is binding.
I understand.
And many courts do. I mean, before every trial I've ever had, they put you in a room or they bring in a mediator, so yes.
So one of the things I'm thinking is that with this process, we could then require ADR before you got to the courts. It would still be in keeping with the process that, might happen anyway.
So I can explain why that's a bad idea from my perspective, and it goes back to one of the fundamental things that other who have testified have said. There is genuinely, and I can speak from experience, a re-traumatization every single time a survivor has to tell their story, whether it's to a lawyer for the first time or publicly in front of a body like this for the first time. It's not easy. And if you require an ADR process prior to access to the courts, what you're essentially saying is you tell your story to the ADR process, you can take it or leave it, and then if you start the fight in the court system, you ultimately have to tell your story again. Whereas in the scenario that you first painted, where you go all the way up into a certain point where the court requires you, whether it's after discovery or prior to trial, they require you to sit down for a mediation. The facts that are being relayed during that process have been borne out of the litigation. And so they're only telling their story once. So to the extent you want to do it in advance of the civil system doing its thing, you're requiring at least two stories. To the extent that it's not binding, but a court requires it prior to a jury trial, which could save taxpayers significant money, that story's already been told through discovery, and then the opportunity is there to use those facts to try and resolve the case.
So generally, if we're looking at family matters, the courts usually require you to go through some type of an ADR process in most courts in Maryland.
I've never been a part of any civil action that did not require alternative dispute resolution before going to trial.
So if we use the courts, once again, we've got to figure out what entity. Perhaps it's the judiciary, perhaps it's a special counsel, a special unit to go through these initially. But if it were the judiciary, but we gave the judiciary some guidelines that said we want all of these to go through some type of an ADR process, with that reporting back, because we still want that, would that be in keeping with something that you would see as fair?
it would be duplicative of what already occurs. If you go to the Maryland City, if you go to the Maryland City courts, there's going to be local rules that require ADR before you ever get to a trial. If you go to Frederick County courts, you're going to see that there's an ADR process that's required before you ever get to a final resolution by way of a jury trial. And so you would be legislating something that's already a part of the system. You don't have to do it. You can suggest it if you proposed in an amendment that, keeping with the current practice implemented across the state of Maryland, that prior to a jury trial, parties are to engage in good faith in an alternative dispute resolution / mediation process. You could put it in writing and pass it, but it's already done. You'd essentially be duplicating what the courts already do. There'd be no opposition to it. It is not easy to go in front of a jury of your peers and tell the story after you've told it in a deposition with a camera and lawyers asking you questions, after you've told your lawyer what happened to you so they could take the case, which then requires you to tell your family for the first time that you were raped in a juvenile detention center. So don't take me as being the person pounding my fist that we want trials, we want trials. We only want trials where there is no other resolution. So no one's opposed to mediation and alternative dispute resolution. It's just how you implement it and making sure that you're not violating the Constitution or Maryland's Article 17 or 15.
I'll have to think about this one. Okay, thank you, Mr. Chair.
Sure.
Vice Chair, the last question for the panel.
First of all, Mr. Stern.
I'm in trouble, I feel like.
No, you're not in trouble. First of all, I want to say to you something I should have said in the beginning, because you did something very heroic today. You shared your story, and you shared it publicly.
Thank you.
So I definitely want to acknowledge that. That is tremendous.
Thank you.
And so I came at you in a way that I probably shouldn't have for you after you had just said that, and I apologize.
You shouldn't. I'm a big boy, and I've got 3 sisters, and
I got it.
I'm good.
I got it. But with that said.
Here we go.
And I mean that honestly and sincerely.
Thank you.
With that said, I still want to just make one thing clear on the record. This is important about these jury trials, and I know that we've gone beyond that, and I don't want to belabor the point too long, but just for a minute, I agree with you on Article 5. I was struggling because we do have small claims court where there are no jury trials. Isn't it true that under Article 5A, Section 2, it states that the legislation can create legislations where we limit the right to a jury trial if the damages do not, or the amount in controversy does not exceed $25,000?
Absolutely.
Okay.
Yes.
Just want to make sure we're on the same page.
And in most instances, Madam Vice Chair, people who have an amount in controversy for less than that amount, whether it's in Maryland or what other states prescribe, those people still have the right to file a case for a jury trial, but they can opt in essentially to a smaller claims court where there is no jury for the expediency of it. Yes, ma'am. Thank you.
Seeing no further questions, we thank you very much. We're going to go to the final panel.
Thank you.
Ben Crump, Tom Yost, John Goldberg. Starting from my right, please put a microphone in front of you so that people can hear. The one to your left is probably the best for the gentleman. Right there, and we'll start from my right, your left, and go across, please. Sir, go ahead.
I guess that's me. I get the left and right mixed up. Thank you, Chairman Clippinger, Vice Chairman Bartlett, members of the committee. My name is Jonathan Goldberg. I'm a lawyer. I am here on behalf of the Maryland Association for Justice and for my clients as well. My office is up in Baltimore. I've had the privilege of testifying before you on other matters this year. It's a pleasure to be back. The CVA was a monumental step to permit survivors who were sexually abused as minors to obtain justice. The House Bill 1378 seeks in some way to take away some of the gains that the survivors have made. I'm not going to try to restate what you've already heard today, but one of the things that I wanted to point out was that, as I understand the more recent amendments, that if you've already filed a case by September or 30 days after this arbitration panel is established, your case gets transferred into arbitration, mandatory arbitration. And if you file after that date, then you have to file in arbitration. And so what I see is that you have, for survivors who were victimized by the state, to then have their claims adjudicated by a contractor who's being paid by the state. And so you have the state who put the survivors in this position now are subject to the adjudication by somebody who's paid by the state. And so how that can give anybody some solace that their claims are being fairly adjudicated, I'm not certain. And the other thing to what was said before about re-traumatizing, again, as I read this, the amendments, the recent amendments, that there is an appeal available after the mandatory arbitration process. Well, now you're re-traumatizing because you're going into circuit court where you're going to have to tell what happened to you again for the third or fourth time as part of this process. So that's not what the CVA was meant to do. It's against the spirit of it. I would ask that the committee vote unfavorable on this bill. Thank you.
Thank you, Mr. Chairman, and to the Vice Chair in her absence. I'm Ben Crumpalone for Adam Slater. We represent thousands of victims. And there was some suggestion made by Chairman Wilson that the plaintiff's attorneys were going to get up here and attack him. I don't know if he's in the room, but I want to set for the record, nobody is going to attack him. I know I certainly was not, and I'm not trying to pick a fight with him. Please let your colleague know we're trying to work with him to find a viable solution to help these victims right these historical wrongs. Because when you look at this amendment, it offers no viability into the process of how the award is decided, who decides the award, and what is the criteria for the basis of the award, as my colleague had just said. And while this is a human rights issue, I believe this is a civil rights issue as well, because a substantial majority of the plaintiffs, over 90% of them, are African Americans. The proposed amendment with the $400,000 ceiling, I believe, is an insult to them, because these African American men and women that were abused and raped as boys and girls when they were in the full custody of the Maryland juvenile detention facilities. And some of them, the girls, were even raped by their guards and staff. And so this suggestion that no matter how many times a victim had been raped, some of them a dozen times, to say your pain, your trauma, your suffering is capped at $400,000 is not just a denial of equal justice. I believe it is a shame before God.
Chairman Clippinger, Madam Vice Chair, delegates, my name is Tom Yost. I'm here on behalf of the Maryland Association for Justice. I'm a past president. I've been before you before, and I'd urge you to vote unfavorably on House Bill 1378. Chairman Wilson is a hero. I think what he's done is the definition of heroic, and I commend him for that, and we're grateful for what he's done. And this committee also, and the House and the Senate, passed that bill. Even the Attorney General, who's not here today, gave an interview, and his face was on the front page of the paper when Senate Bill 686 came up for a hearing the day before. He was on the front page of the paper saying, I support the CVA, I support the constitutionality of it, and we'll defend it. Recently, in the last couple of years, the federal government banned forced arbitration in sexual harassment contracts, employment contracts. So it's illegal. You can't do that. That's a move in the right direction. This bill is a move in the wrong direction. The arbitration, their ADR, arbitration, whatever it is not defined, and it's not left for you to make up. This bill says that the executive branch of government will make it up, and there's no time frame. And they said you have to go in there. That's a really bad thing because they don't tell you how you get out of it. If you don't like the decision, you can have a right to jury trial. What if they don't decide your case for 3 or 4 years? Well, they say there's so many cases, they don't have the people. They've already had 16 months since the CVA took effect. They signed it into law almost 2 years ago, and they still don't have a framework to do this, how to work this out. So there's an inherent conflict of interest. It really needs to go to the judicial branch of government, which deals with all of these issues. And they can fix this. They can make it work. And arbitration, if it's voluntary, is fine. It should never be forced, especially in this situation. Thank you.
Questions for this panel? Delegate Sample Hughes.
And thank you, gentlemen, for all being here today. If you could, just for me, just expound upon a little bit more about the time limit. You had talked about the ARD. I'm not that familiar with that piece.
Thank you for that question, yeah. So what the bill says is that the governor shall designate a state entity to implement and administer the program. He's going to name an entity. The designated entity shall contract with third parties to operate the alternative dispute resolution process, make determinations as directed by the designated entity for resolution of claims, and adopt regulations to carry out the requirements. And then it says there's no transparency in who they pick to do this. There's zero transparency in the paragraphs below, zero transparency in how they make up those regulations. So the people that were asleep at the switch, not this administration, but decades of administrations, the executive branch that was asleep at the switch for decades is now going to be in charge of when they get to it. They've had 2 years already. When they get to it, they're supposed to create a system that you must go in, and they don't tell you how you're going to get out. Now, if there was something there that said you can opt in if you want to or opt out, that's fine. I'm in a case, and the lawyer called me up yesterday, and we're in the middle of discovery. She says, we should talk about mediation. That means there's enough evidence there to prove your case. It's time to talk settlement. And that's really what you've heard from the other lawyers. You need to get the facts and the data and the documents from 10, 20, 30 years ago. You need to get those records. And once you have all the evidence in front of you, then you're in a position to prove the case and how strong your case is. You don't want to go into an undefined agency that the executive branch of the government doesn't even exist yet. They don't even have a name for it yet. But and they don't have rules, they don't have a framework, and they don't have a time frame. This is another delay, and that's the problem. It's a dark hole. It's a black hole. You don't know where it is. And the people that suggested that this committee is going to make those regulations and rules, that's not what the bill they want you to vote says. It's the opposite of that.
Okay, just one last thing, Mr. Chair. So we had legislation that puts parameters on. This is dealing with law enforcement, and I'm just trying to see if you're talking about in that same manner. Like there was 366 days that this had to be done, and then the next step, or something within that time frame. Is that what you're trying to outline within the process that's in this piece of legislation?
I think they should use the existing judicial arbitration ADR process. I think that is tried and true and proven already. Okay. I think they should do that. You usually do that after discovery is over. That's how that works. If they want to have a bypass program where you can come in, tell us about your case, and we're going to make you an offer, I think there's a lot of people that want to do that. But the survivors of sexual abuse should have a choice. It shouldn't be mandated, just like it isn't mandated any longer in sexual harassment employment contracts.
And Delegate, if I can add to that, which may go to your question, when you file a case in court, you get a scheduling order, and that tells you when deadlines are set for naming experts, completing discovery, when ADR should be accomplished by, and then a trial date. So once you file that lawsuit, you're on the clock, and you know when the end date is. In this current system, as Mr. Yost was saying, there's no guidance at all in that regard.
Okay, thank you. That's kind of what I was looking for. I'm not an attorney, so I'm just trying to look for additional guidance. So thank you for that information.
Yes, ma'am.
Thank you, Mr. Chair. Mr. Yost, I know you've been practicing law here in the state of Maryland for a very long time. We're in a very different situation, and as stewards, fiduciaries of the taxpayers' money, we really have to think things through on this one. I voted wholeheartedly for CBA, and I believe in it. At the same time, I've got to say that this is impacting the state of Maryland, or it has the potential to impact the state of Maryland in a really challenging way. So having this perspective, you're sitting in our shoes. One of the things that we're trying to do is navigate this in a way that is fair to the victims, that moves things through in a timely manner, and provides some level of certainty as we figure out how we budget and facilitate this. This, in my mind, is a start to that. So taking this framework, how would you suggest, sitting in our chairs, that we use this framework potentially and kind of come up with some compromise?
Let me start out by answering a question you never got an answer to before. The attorney fees in Maryland for claims against the state are 20% if you settle and 25% if you go to trial. We don't get anywhere near as much as the people in California. That's first off. I think this is a nice.
Let me ask you, so do we say that in the CBA? Do Maryland tort claims apply?
That's in the law. It's in the state law. That existed before the CBA.
I understand.
It applies to everybody in the CBA.
Okay, all right. Very good.
It's applicable to everybody in the CBA. We all know that.
Okay.
I think you heard from Mr. Freeman before. Andy Freeman was sitting all the way over here, guy with the gray beard, and he said, look, you need a working group. They don't even have an arbitration process yet. How can you vote on, this is ready, shoot, aim legislation. You know, we have 2 weeks to go. The bill gets dropped. The bill was one thing on Saturday, a different thing on Sunday, a different thing on Wednesday. And so we're all here, and there's proposed amendments and thoughts about it. But the reality of it is they should come up with an arbitration process. It doesn't have to be mandated by this branch of government. They can just offer it to people, and some people will absolutely just go there right away. What they shouldn't be able to do is put a finger and say, freeze, your case is going to be held for 2, 3 more years after the 16 months they waited for the Maryland Supreme Court to declare the CBA constitutional. When that happened, everybody who had filed, that was it. There was no litigation. So wait till the Supreme Court rules. So for 16 months, every case that was filed sat, mothballs, cobwebs. That's what's happened for the last 16 months. This bill is just another effort, a dark hole of delay. We can't even tell you how long the delay is. And if it's mandatory, if the arbitration is mandatory, that's guaranteed delay. Even if they say it's just 6 months, it's 6 months of delay. If we don't give you an offer in 6 months, you can go file your suit or move forward in your suit in court, right? It's still a 6 months pause. None of these cases will go, and if you file a lawsuit today in, let's say, most busy courts, 18 months to 2 years to get your trial. Every case that was filed a year ago, 16 months ago, they're about 2 years out, 18 months to 2 years out from now for trial. They have plenty of time to sort this out. And there's ways to fund this, and it's been discussed. And they can issue a bond. Now, nobody expects the state of Maryland to be able to afford 80 years of sex abuse claims in 1 or 2 or 3 years budget. That's just not reasonable. They say the number is really big, but what if you divided the number by 70 years or 60 years? It's probably not that big anymore. It's probably just the right number. But how do you do that if you're the state government? You go, you figure out, get a good idea, best idea, you issue a bond, you sell the bond, and you make payments on it over 25 or 30 years, and you pay the people out of that money from the bond issue over 5 years, and you catch up with everything. That's been floated. That's a possibility. It doesn't bankrupt the state. It's just a question of meeting your obligation that you all passed, the CVA obligation that the state has. They just didn't know how much harm they caused. Nobody knew. Nobody knew. And that's what we're dealt with here. So how do we deal with this? let them develop an arbitration process without the legislature, right? Let them do that.
And I like the concept of developing the arbitration process, and that's why I like this bill. I'm not sure that we're going to leave that as the General Assembly for somebody else to do. In my mind, I think we need to be involved in that process. So I'll just share that with you. Thank you, sir.
Thank you.
Thank you all. Thank you all very much. That appears to conclude the questions from the committee. It concludes the testimony for House Bill 1378. We're going to move on to other legislation now, including Senator Jackson, who has been hiding in the middle of the room. And we will hear his bill, Senate Bill 271 now. We'll give people who are leaving the room the opportunity to leave quietly. Please, to leave quietly, so that we can continue our work, please. Senator Jackson, we're going to hear your bill right now. It's Senate Bill 271. And we'll hear from you and your witness. Thank you.
Thank you very much, Mr. Chairman. Members of the Judiciary Committee, for the record, Senator Michael Jackson, representing District 27. I am proud to be joined today by one of the sheriffs of one of the 3 counties that I represent, Sheriff Ricky Cox from Calvert County. Mr. Chairman, Senate Bill 271 is the Maryland Tort Claims Act. This bill was brought to me by the Maryland Sheriff's Association. The bill simply provides clear protections to the civilian employees of the sheriff's offices here in Maryland, as are in statutory language for state's attorney's offices, even the liquor boards and boards of elections. In short, Mr. Chairman and members of the committee, we have gone through great lengths to make sure that law enforcement officers are protected through the Tort Claims Act. And what we haven't done, we failed to do, is for the civilian employees who are serving under the auspices of the sheriff in this case. So I will turn the rest of my comment time over to the sheriff, who's here representing the association today, and we ask for a favorable report. I'll stand for questions.
Mr. Chair, thank you, Senator Jackson. Thank you for the record. Sheriff Cox, representing Calvert County and the Maryland Sheriff's Association. This bill really is real clear, real easy, as the senator said, and a lot of times our civilian staff or support staff within the sheriff's office, they deal with the public more than we do, in a sense, in some cases. And a lot of times when we deal with lawsuits and the PIA requests that we get, I mean, these things are through the roof as far as body cam footage. There's a lot of work involved and our support staff's involved. But when it comes down to the lawsuits, they're not being representative and protected like we are in sworn personnel. And I think this bill right here closes that whole law and the legislation together and allows that the civilian staff and our sheriff's offices throughout the state be covered just like we are. And that's what we're asking for today.
Thank you, Mr. Chairman. Thank you for coming in to testify today. My question to the senator is, what is the limit that you're asking for the torts claim?
I couldn't hear you.
What's the limit that you're asking for?
The limit, it's the limit that's in the statute, just as it is with the state's attorney's offices. There's a limit set for the civilian employees of state's attorney's offices, liquor boards, boards of elections, and others.
Is that the same limit as the sworn officers?
I am not sure of that.
Okay, that's good. Thank you very much.
Yeah, I mean, the protection would, the Attorney General's office represents every sheriff within the state and legal guidance as well. And what this does is they allow the Attorney General's office to represent our civilian staff as well. That brings that together.
You knew what the cap amount was?
I do not know, no.
Okay, thank you very much.
Anyone else? Seeing none, we thank you both very much, and that concludes the testimony for the Senator Jackson's bill. Senator Simon Ayer is here. Senate Bill 123. We have heard this bill, so it's just a sponsor-only bill, I believe, and here he is. So we'll hear from Senator Simon Ayer, please.
Okay, I follow directions.
Yeah. Well, thank you. This is Senate Bill 123, hit and run on our waterways. This is a sponsor-only hearing. I wanted to recognize the Slattery family. They were in the hallway. I don't know if they realized everybody left that they could come in, but they're here just to show their support. This is a cross-file of House Bill 676, Delegate Schmidt, but it's not in the same form. The Senate added an amendment realizing the unique situations on the water, and it provided more flexibility regarding the requirement to return to the exact location. So it just gave them some more flexibility on that. I wanted to say it's important to note that this bill does not create a new crime, but it alters the scope of the crime. The bill says that the crime applies whether an individual is on land or sea. And quite frankly, I thought this was going to be an easy bill, as it's a matter of fairness. If someone knew that a boating accident might result in death of another individual and leaves the scene on the water, they only get a $500 citation for that action. That's exactly what happened, as you know, to my constituent who lost his wife during a hit and run on the water. Had the accident happened on land, Maryland law would have allowed more appropriate penalty. If our laws protect our residents from hit and run on land, it should also protect our residents on the waterways. I realize the House has not moved the House bill yet, but my ask is that you would move both bills in the form that the committee approves and provide some protections against the cowardly and devastating act of hit and run on the water. I know there's a lot of clever and caring people on this committee, and if this proposal isn't exactly in the form that this committee wants, Delegate Schmidt and I are open to committee amendments. And I did look at the House hearing, and I noticed that there was a comment about possibly amending the bodily injury versus seriously bodily injury. I just wanted to note, this is in the exact same form as it is in the transportation, and I think what they do is, so the bill's the same as it is in transportation. I think the first part deals with bodily injury, that you just render assistance, and then when they have the penalties, they talk about serious bodily injury. So I would just ask that you would move something and help provide some more fairness in our laws with that. So.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Senator. Real quick question. Isn't maritime law different than land law?
In some cases, if you murder somebody on the water, it's not. There's plenty of cases where the crime doesn't matter the location. And in this case, when you're leaving somebody who could have a sinking boat and just leave them to die and you leave them, I think that's the same as if you did it on land and you didn't provide any help and you just left them to die.
You think the penalty's the same?
Yeah, I mean, and originally, this bill was to create parity in the sense that it's the exact same crime on land.
Yeah, I'm not asking philosophically, is it the same crime? I'm asking, aren't there two different governing bodies, one for the water and one for land?
In some cases not. Okay. And I'm saying this should not be one of those cases as well.
All righty, thank you.
Other questions from the committee? All right, thank you very much.
Thank you.
That concludes the testimony on Senate Bill 123. The chair of JPR hasn't made it yet. I'm trying to avoid bills that are getting more of a full hearing, but that's all right. I think we're just going to have to get on with it. Senator Lamb, Senate Bill 977, please.
So good afternoon, Chair Clippinger, Vice Chair Bartlett, members of the House Judiciary Committee. For the record, Clarence Lamb, Senator District 12, requesting a favorable report on Senate Bill 977, here introducing the Maryland Data Privacy Act. This bill is a cross-file of HB 1431 that the committee has already heard. This legislation builds on progress that was made in the 2021 Data Driver Privacy Act to protect Maryland driver's license data from warrantless federal intrusions. You may recall that a couple years ago, we had found out that the U.S. Department of Justice's Immigration and Customs Enforcement Division was accessing our state driver's license database through some arrangements that have been put in place many, many years ago, and running facial recognition on our driver's license database. And so we were obviously concerned. There also is evidence showing that when it comes to facial recognition, it has higher error rates with people of color. And as a result, in 2021, we passed the Driver Privacy Act to ban this practice. And it requires that if the federal government is requesting this information, they have to have a warrant signed by a judge. Under this current administration, we're now seeing more aggressive immigration enforcement, including a tenuous or questionable resurrection of the Alien Enemies Act. While you may have heard about the Alien Enemies Act in the news over the last few weeks in reference to individuals of other nationalities who are being detained or flown out of the country, there are rising concerns about how it can be used against permanent residents, green card holders, and even citizens here in the U.S. This law, it was the same law that was used to justify the improper internment of Japanese Americans during World War II. Furthermore, there are broad questions about the safeguarding of our personal information, whether we are directly descendant immigrants or not, with questions about federal officials and their access to things like Social Security databases, IRS databases, and a lot of other databases that contain our information regardless of immigration status. Thus, while we can't do anything about potential federal overreach of data in possession Okay. At the federal level, we believe it's essential that the state and local agencies can take steps to prevent misuse of sensitive data that the people of Maryland have entrusted our state government with. There are significant changes to the bill since its introduction, since the House version was initially heard by this committee. So I'm going to take a moment just to speak to the Senate version now as amended. This bill seeks to prevent federal agents from accessing data about Marylanders without a warrant issued by a state or federal court. It also requires agencies to document and report to the General Assembly and the Attorney General all access requests and whether they were granted. These provisions are simply seeking to extend protections the General Assembly has already provided to those driver's license database information that I referenced, and also to databases maintained by law enforcement. That was also included in the 2021 bill that is now
Stop
statute.
right there. Let's do this. Are there questions? Yes. The chairman.
Sure.
Tell me about the rest of the Senate amendments. Keep going.
Oh, yeah.
Keep going. We're
Okay.
just trying to stay somewhat close to the 3-minute rule for spots.
Sure, apologize. This is the first time here in this committee this session. So just really briefly, it also has a provision requiring that data brokers must hold that data private and cannot have that data sold by data brokers. Data brokers oftentimes are holding this data that state agencies have. And so there's collection of this information that would be provided by the Attorney General and also reporting. So I think that's actually the provisions of the bill as amended. There were provisions that were taken out, and then significantly the data broker provision was put in by the Senate JPR committee. Happy to take any questions.
No problem. Delegate Eric had Ned, and then I see Embry.
Thank you, Mr. Chair. You senators are so polite, man. You stop right. I've never heard it before. We don't even do that with our own members. So,
well, over there we give unlimited time to the sponsors.
Oh,
so
do you? Okay.
Apologize to this
no,
committee.
you guys are very sweet. Okay, so but on the bill.
Sure.
We had the ICE director come in, and I talked pretty at length with him, both in the committee and outside, and he explained to me what the warrant process looks like for ICE. ICE actually has in-house warrant processing. So no matter what we put here, when they go to get a warrant, they don't have a judicial process. It's inside their own department. They go and they get a warrant, and then they go do whatever they want. Did you know that?
We had heard about this process, but what this bill states is that they still need to get a signed warrant by a judge.
They can't. It does not exist in the federal system. There is no opportunity for them to do so based on how they're structured in the federal government.
Well, we have that as our current state law already for any access to, for example, driver's license databases, law enforcement databases. That's already in state statute. So either they're not accessing any of that current information, or they have a way to be able to get a judge to sign a warrant to do that.
It's not a judge, and it is in-house, and that is what they do. And I don't see the federal government at this point changing that to allow them an avenue to meet these qualifications?
Well, these would be requirements that we would have to protect our own state database. If they want to access that information, they'll need to figure out a change in their process or figure out how to get a judge to sign off on that.
So you're not worried that denying them would be a violation of federal law?
I think this is data that's within the state, and so they're controlled by state law. There are already things in statute, as I mentioned, if they wanted to go access our driver's license database or any law enforcement database, already in statute, there are limitations that require judges sign warrants.
Well, they do get warrants, but they're not in a judicial setting. That, I think there's going to have to be some conversations if you guys do want to make this functional and without violating federal immigration law, that you'll have to have a talks with them, because there is currently no judicial system set up for ICE anywhere in the country to get warrants in that way.
Thank you. Thank you, Senator, for this very important legislation. I wondered, the issue raised by the university system, because they sponsor students with visas and have to have interactions about those students with the federal government. I wonder if any of the amendments address that, or if you believe that this law doesn't apply to that, or I just wondered if you could respond to that concern.
So I know that they had voiced some concerns about compliance with I-9 disclosures, and we're open to trying to figure out how we can make sure that they're held harmless when it comes to those types of disclosures. We have reached out to the USM office to have that conversation. I don't think this bill would prevent any type of intrusion from their ability to be able to make reports that they're obliged to have to compile and provide. It really just prevents immigration officials from accessing this data without a signed warrant by a judge. So, you know, I think we're open to any clarifying language that they can provide to us.
I have questions about constitutionality. Have a letter that requested from the Attorney General that says that there are significant First Amendment issues and speaks to, although there's not a First Amendment right to government data, that the Attorney General would likely view the bill's restrictions on the redisclosure of data, which is in the bill, as content-based, as a content-based law, because they only apply to records containing personal information. How would you address that issue?
You know, I think state agencies hold a lot of information that is content-based, and we've been able to find ways to ensure that that information that's within various state databases or state agencies or entities can be retained privately, even though, you know, it is kind of content-based on the fact that somebody has submitted information to a department or an agency, or it contains, you know, information related to their health or something that, you know, I'm not sure that that is a restriction that would be an issue with this, but open to thoughts on how to make sure that that's
I guess my
addressed.
concern is it's kind of the sum and substance of the bill, and what they're saying is that they believe that because it would be a content-based restriction, that it's facially unconstitutional, and that may be a problem going forward. I guess the other question I have is, how does case search work? Judiciary case search work if you pass this bill?
So we're open to so I did read the letter from the Judiciary. We're open to writing the Judiciary out of the bill to make sure that it doesn't affect case search and Maryland electronic courts, for example.
Okay, how about the voter file?
The voter file is
from the Board of Elections, taken by a private company and put into a form that people can search. How would the voter file be impacted by your bill?
So the voter file is public record, and we do have a provision in here saying that the covered record is if the covered record is otherwise made available in other ways that are available to the public, that it would be exempt from this.
But if it's sent to another place, how does that work? There are companies that then, my understanding of the voter file is that there is a private company who takes the information from the public source, and it seems to be, again, part of what you're trying to do in the bill. I'm happy to talk with you more, but I think there's another issue with that we might have to look at. All right, are there further questions? None? Thank you very much.
Okay,
We'll
thank
get you
you.
a copy of the AG's letter, by the way, if you don't mind. We'll go to the chair of JPR. And I'm just going to point out, all the other senators are now angry because the chair of JPR is jumping in front of them. And
Oh, wow, thanks.
yeah, I know. It's tough.
Oh, my God.
It's tough.
Just maybe the most popular person in the Senate right
Particularly
now.
Senator
Thanks, appreciate
Kramer.
that.
He's, it's tough. Did it out of
Delegate
love.
Phillips,
All
if you
right.
watch it.
Senator,
Which one would you like me to start with,
let's,
Mr. Chairman?
let me see. Let's do 443 with Mr. Jocelyn and Mr. Rosenberg joining.
Sure.
So Mr. Jocelyn, there's Mr. Jocelyn. So we'll start with 443 and then we'll go to 828.
All right, Mr. Chairman, Madam Vice Chair, members of the Distinguished Judiciary Committee, this is Senator Smith here to enter into the record Senate Bill 443, which is a very simple. It just makes trafficking of a firearm a felony. I believe that was actually nested in a bill that you all passed earlier that's on third reader now in the Maryland Senate, Delegate Moon's bill, House Bill 431. This effectively does the same thing that's part of that bill. You have people here from LifeBridge. I suggest you all take an opportunity to look at something called the Iron Pipeline. It's on the website. It talks about how many, because Maryland is situated in the Mid-Atlantic along the 95 corridor, most of the guns that are trafficked here illegally that end up in crime guns are actually from out of state. It's a significant problem that we face. So I think this aligns and comports with what this committee has already spoken to and good public policy for the state of Maryland. But like I said, this bill, I think this entire bill is nested within another bill that you already passed. So with that, Mr. Chairman, I'll leave it to the committee's wisdom and judgment and stand by for questions after the panel presents.
Good afternoon, members of the committee. Am I on? Good afternoon, members of the committee, Mr. Chair, Madam Vice Chair. I'm Adam Rosenberg, the Vice President for Violence Intervention and Prevention at LifeBridge Health, testifying in support of Senate Bill 443. One of the things that we've done as a health system is leaned in on the problem of gun violence. When guns have become the #1 killer of children in America today and in Baltimore, we recognize that as a health system, we need to be doing things about it there. One of those things that we saw we could take action on is, just as Senator Smith referenced, finding ways to stop the iron pipeline. And so we have worked with a number of people who've generously donated their time and their media to raise that issue there, because the fewer illegal guns that come into Maryland there, the fewer bodies that we'll be seeing in our emergency rooms and our post-care clinics after people have been shot. It is one of those things that we, when we look at all the evidence, can agree upon, that there are legal ways to own firearms and weapons, but the illegal trafficking of firearms goes against everything that these committees have been trying to do, to be able to set up proper standards and procedures on that there. You have a copy of my testimony, and I am available for further questions on that, but we strongly support it and ask for a favorable ruling. And I would only also add, I just am deeply appreciative, being a victim-serving agency, of this group's advocacy and support of VOCA funding that was in the budget that you dealt with this morning. So truly thank you for that as well.
Good afternoon, Mr. Chairman. John Jocelyn speaking for 2A Maryland. For the record, this may be the only time you ever see me sit next to Chair Smith and we agree on a bill. I will endeavor not to let it happen again.
You and me both, all right? Okay.
That being said, yes, we do support raising the offense to the level of a felony. We do believe it's a serious problem, and therefore we are supporting this particular piece of legislation as it's currently written.
Questions to the panel? Thank you. Whoops, Delegate Conaway.
Mr. Chairman. Thank you, panel, for coming in, Senator. My question is, originally, when the idea was put forth, was the idea put forth that the citizens would have the right to bear arms with a permit?
With a permit?
Yes.
Absolutely.
No, was that the original idea of allowing citizens to bear arms?
Oh, well, that's a longer, more existential question of Second Amendment interpretation, but
okay.
Yeah, I'm glad we do have safety requirements and regulatory requirements.
Well, I understand. I'm glad too, but
firearm ownership.
I'm just saying your specific rights could be what they call a bridge. But I thank you very much.
I appreciate that.
Anyone else? Seeing none, thank you very much. That concludes the testimony on Senate Bill 443. We'll go to Senate Bill 828, and it's this time just the chairman. Sensitive locations.
Thank you very much, Mr. Chairman, Madam Vice Chair, members of the committee. I'm going to walk you through the bill just as it's drafted to kind of explain the four component parts of the bill, because the way that it's drafted, it could lead to some confusion. So I just want to make sure that there's a proper presentation of the bill. So essentially the bill does four things. It sets forth a warrant requirement for public spaces that are not publicly accessible in what the bill enumerates as sensitive locations. It provides for the Attorney General to provide for guidance for sensitive locations, and that's more of basically it speaks to these locations. It doesn't mandate any requirements, but it applies to those locations. And there's guidelines for private entities to include houses of worships. Again, it's not mandatory guidance that you'd have to adopt, but it's guidance that speaks to those entities. And then there's a fourth part in the bill, which is the last page, which basically deals with the policies that those sensitive locations that are government entities have to adopt. So look, if we go to page 2, you're looking at, there are a couple points that I want to make sure that the committee understands. Page 2, lines 8 through 9, that is because under current law, we have the 287G program only applies to detention centers. So that's a carve out to make sure that it doesn't apply and we wouldn't run afoul of current law. I know that there is a bill pending that might broaden the prohibition of 287G programs, but since that bill is still pending, that's why this is here. Then you'll see that the sensitive location is a public school, public library, or a unit of executive branch state government that operates at a sensitive location. This is the warrant requirement. They have to deny access to the ICE official for immigration detention purposes, and they have to have a judicial warrant. And there's the difference between a judicial warrant and the ICE detainer. So those are two different things distinguishing there. There's a carve out for exigent circumstances. Moving along to page 4, this is the guidance for those sensitive locations. And again, those locations are enumerated out. So public school, public library, healthcare facility, and so on. And then if you go down to subsection B, lines 22 through 24, again, that just affirmed that's the guidance that has to be issued to those aforementioned entities. That's guidance. And then finally, you go down to the policy piece, which is on page 5. This is on or before, this is subsection D, lines 7 through 10. This is by October 1st, all of those sensitive locations that are government entities that are not publicly accessible, they have to implement those policies that are consistent with the guidance that the Attorney General promulgates under the bill. And with that, Mr. Chairman, I'll rest and take questions.
Let me ask a couple questions. I saw that there was the warrant requirement, I guess, is one of the bigger questions that I have. One of the questions that I have relates to in the Senate bill, it would allow circuit and district court judges to issue a warrant to presumably federal immigration authorities to engage in this work. And how does that square constitutionally?
That works. So that's, as Senator Lamb alluded to, when we passed a bill to limit access to federal law enforcement access to our MVA data, we set forth the same requirements of either a federal district court judge, federal judge, or a state judge could issue that warrant. I think that's consistent with the 10th Amendment and its interaction with Article 1. meaning the 10th Amendment is like everything that's not specifically enumerated for Article 1 powers is reserved to the states. And that's that tension. You see that in what's called the commandeering clause, or the commandeering clause, where the federal government can't take local law enforcement or state law enforcement, for instance, and federalize them, use them for federal purposes without the state's consent. So I do think it's consistent with 10th Amendment principles. It's worked with the MVA bill that we passed a couple years ago. It's, I think, been litigated in several different districts.
Is there a concern that circuit court or district court judges would not have the expertise in federal immigration law to know what is properly within the four corners of the warrant?
It's functioning this way right now. And so, again, I would just lean on the 10th Amendment and that I mean, those judges are required to make that analysis all of the time under questions under the 10th Amendment. So I think that's probably working and function already. So the answer is no, I don't have those concerns.
Okay. The other question I had about courthouses. So you need a warrant to be able to go into a courthouse?
We took out courthouses for the warrant requirement.
Okay, I thought I saw it in one of the versions of the bill. I just,
No, that was
if it's
under
not there, then
that was
great.
under the initial version, but obviously, respecting separation of powers and in discussions with the judiciary, we took that out.
Okay.
But
I think that the work that you know, requiring public facilities to have policies in place makes a lot of sense. And I think that the guidance that we were asking, both the House and the Senate were asking the AG to provide guidance that was relatively similar, although I would argue ours is maybe a little more expansive, but okay.
I agree, yes, Mr. Chairman. I agree it's more expansive, but in listening to the Attorney General and understanding the client base of the Attorney General and the Attorney General's comfort level requiring certain entities that are not the client of the Attorney General to adopt policies at the Attorney General's direction was probably a bridge too far, and that's why we pulled it back.
I see. Okay. And yours only covers public places, not private places, where the House bill at least sort of comes closer to some private places.
I think that's correct.
All right. Delegate Arikan.
Thank you, Mr. Chair. Thank you, Mr. Chair, for being here as well. Okay, so you had touched on the the administrative warrants versus judicial warrants. I know Senator Lamb had said that we already have some requirements, but to my knowledge, that system is basically not used.
There was a reporting requirement, and I would say not used, but we asked we had required how many inquiries are made. There were 2.
Okay, so twice ICE has gone to a judge for a warrant, is that?
And they've tried to access it for immigration purposes, so it's twice. It's a self,
Okay.
yeah.
Yeah, because typically when they do, when they have interactions, they actually don't enter homes without permission. They basically knock on the door and somebody answers, typically. So, yeah, and when I actually asked them about, we had obviously a very similar bill, they didn't think it would really impact them at all since they don't go into these locations.
No, I mean, under current, well, in Maryland, we don't, our 287G framework doesn't allow for like the field enforcement.
Of course, yeah,
so,
yeah. But even separate ICE agents, so we have like the 287G in-house, which are like essentially deputized.
Yeah.
But then the actual ICE agents, when we talked to the director of ICE, he's like, we would never go into a public school or a library. He said he's never organized any type of operation in any of these listed locations. It's just, there's too much risk for collateral.
So, yes, the delegate. So that, I have spoken to him as well, and that was the testimony. I will also say that I heard from 2 U.S. senators that had, and just because I'm affording the credibility of this story because it came from the source, I talked about a couple of instances in Frederick where, that was not the case in terms of hanging out outside of the school, by a school stop, apprehending parents, children having to go home without their parents there, figuring out how to get to and from school before the school said, hey, what's going on here? Did a follow-up check to ensure that everything was okay. I also know that same person, same conversations, that there are subjects of ICE detainers and warrants, but that whoever else is in that person's purview. If they are there, they will, and they are not here, if they're a non-citizen, they will go ahead and collect that person as well and initiate the deport. They will engage in collateral collection of folks.
Yeah, which is why the 287G program is so helpful, because it avoids that collateral, right? Because it's only the person through the prison system we would pick up versus having them go to the home or try to grab somebody in the car where there's other people present. Do you know what I mean? So we're actually, if we start shifting out away from 287G, we're shifting towards collateral pickups.
No, I would argue that the 287G program is not necessary because what the 287G program gives you is some training, which is an annual training, nominal training really, and resources. I actually went up and saw one of these operations up in Hartford County.
That's Ryan.
That's why I mentioned it. And so the training's there, and there's some money. And like you said, they've got the portal there, and they've got a couple of agents there. But there's nothing in the law. If you get rid of 287G, that's just basically saying that we're having a financial incentive to engage in this practice. But there's nothing in the law right now, if you got rid of 287G, that prevents counties from cooperating to the extent that they feel is necessary with ICE officials. In fact, that's happening in several jurisdictions. In my home county, it's happening.
Yeah.
I know the bill that you all, this isn't this isn't a bill hearing on that bill, so I don't want to waste too much time, but happy to speak with you more online. But it is, that level of cooperation is happening without 287G. So I don't think it's really necessary.
Okay. Well, I appreciate you coming in on this and explaining how yours differs from ours.
Anybody else? Seeing none, thank you very much. That concludes the testimony for Senate Bill 828. We'll go now to the chair's last bill, 444. Senator Smith, again.
Sure thing.
With Adam Rosenberg, Ramya Swamy.
Thanks.
We have one in opposition, so we'll hear. Go ahead, Senator.
Sure. Thank you very much, Mr. Chairman. So I'll be very quick with this bill. I know you've had a long day. This bill doesn't speak to whether or not you should have gun buyback programs or whether they're good or bad, but it does say that if you do conduct a gun buyback, that you shall ensure the obliteration of the entire firearm. Right now, only the serialized portions of only the pieces that are considered to be registered are firearms. So like the frame and the receiver are required to be destroyed. But all the other component parts, like the barrel, the trigger, the grip, the slide, for instance, are not included in that definition of a firearm and so are not required to be destroyed. This bill says you've got to ensure that the entire firearm is obliterated if you conduct a gun buyback program. There is a provision that we added in to ensure that if a firearm, that they run a check to see if it's stolen and to see that if it's a crime gun, which is standard practice now anyway, but we codified it. And then it initiates some penalties for failing to adhere to this new law. That's all this bill does. And for brevity, I'll wrap it up right there, Mr. Chairman, and I'll stand by for questions.
Thank you, Mr. Chairman, members of the committee. Thank you, Senator Smith, as well, for introducing this bill. Adam Rosenberg from LifeBridge Health. Again, reiterating similar to our position with 443, LifeBridge Health believes that we need to do as many things as possible to reduce the number of guns that are on our streets that can end up killing lives and harming people, that end up in all of our hospitals, emergency rooms, costing us a great deal of pain and agony, as well as the unfortunate rising cost of healthcare and just the cost of this traumatic gun violence there. By having a procedure in place to ensure that guns which are brought back in these processes have a mandatory destruction to it, prevents those guns from possibly falling back out into streets, to being able to lead to further death and destruction there. And we are supportive of these measures, which again I think are sensible measures to be able to provide a framework around the buyback of weapons, and which is a program that works and is necessary to be able to continue to keep a healthy community there. And so with that, I thank you.
Questions? Delegate Conaway.
Mr. Chairman, thank you, Senator and panel, for coming in to testify. Who exactly might not be destroying the whole firearm in a buyback program?
So to do this, you have to be a law enforcement agency or an FFL, and usually what happens, you team up with like a community organization or a church, to do these things. So what is not required under law is to destroy every component part of the firearm. So for instance, we've done a lot of good work for, again, to outlaw ghost guns or unserialized firearms. If you're able to resell those component parts, it makes it easier for you to facilitate the creation of new unregistered, unserialized firearms. And so
So you're saying not law enforcement, but maybe the church or something is intercepting these parts and breaking it down, and then they're selling the receivers or whatever, but they're keeping the other parts? Or are you saying law enforcement might be doing it?
it's the law enforcement agency that has to facilitate that process.
Thank you, Senator.
Further questions, Delegate Williams?
Thank you, Mr. Chair, and thank you, Senator Smith, for bringing this piece of legislation. I actually really like this bill. I noticed, I was looking at the letter from the chiefs and sheriffs with regards to their amendment that they were proposing. I mean, I think you capture a little bit of it. I was looking at the third reader of the bill that passed out. But, they wanted to be able to conduct an investigation of any of the guns that they collect with regards to, or in addition to destroying the firearm. Just wanted to kind of get your thoughts or feedback on that.
Sure, I worked with them and a Republican senator on the floor to ensure that the language was tight. That language can be found on page 4, lines 17 through 22, under subsection 5-904. I believe that assuaged their concerns and addressed the senator's concerns as we move the bill forward.
Okay, just wanted to double check. Thank you.
Thank you.
Ramya Swamy has joined us virtually. We're going to hear from her for 2 minutes, please.
Thank you. Good evening, Chair Clippinger, Vice Chair Bartlett, and members of the Maryland House Judiciary Committee. My name is Ramya Swamy, and I'm Policy Counsel for the Brady Campaign to Prevent Gun Violence. Thank you for the opportunity to speak in support of this bill. I'm not going to go over in my testimony what the bill does, just because the sponsors and the other panelists have done that. Thank you very much. I just want to highlight that reporting from the has found that while many law enforcement agencies promise that firearms turned in at gun buybacks will be destroyed, the companies that they're contracting with only destroy specific parts of the gun, which allows remaining components to be reassembled into a working firearm. And this bill, with the implementation of a gun buyback program and destruction policy, will increase trust between law enforcement and the public. Gun buybacks typically announce that the firearms turned in will be destroyed, and people who turn in their guns at buybacks have chosen that option rather than to sell them at a pawn shop or in private sales, and their expectations are thwarted if the vendor that supposedly destroys the guns instead then sells the parts for assembly into a new gun. When a crime gun is taken off the streets and required to be destroyed, it should be fully destroyed, not live on in another gun that has just one additional part. Destroying a gun that has been used in crime is a common sense way to ensure that the gun will not be used in future crimes. No crime victim should have to find out that instead of being destroyed, the parts of a gun used against them in the commission of a crime would be reassembled into a gun again and possibly be used in additional crimes. Nor should there ever be a new person victimized by a crime committed with a gun that should have been destroyed rather than recycled into a new weapon. This bill is a common sense safety measure that will keep Marylanders safe, and for these reasons, I respectfully urge a favorable report on this bill. Thank you.
Thank you, Ms. Chair. So I just heard her testimony, but you had mentioned that you had worked on language to kind of make sure that it was used in a crime or was stolen, that that wouldn't happen. So that's, I think what you're talking about is page 3. It says it does not apply to a firearm if the law enforcement agency determines the firearm was stolen or is evidence of a crime. Does that carve that out?
That's right. And then again on line 4 or page 4, which just says that they have to make reasonable efforts. So the law enforcement agency that receives a firearm as part of a gun buyback program under the subtitle shall make reasonable efforts to determine whether the firearm is a crime firearm or has been reported lost or stolen. That was just to, used to assuage some of the concerns from the members that if one member had gone away on a trip and her farmhouse where some of their firearms were safely secured was stolen, and she was on vacation, came back, reported they were stolen, and wanted to make sure that if someone went to a gun buyback program and sold those firearms, that they would do a check to make sure, oh, these are reported stolen, let's return them to the
so this language should allow for the individual who's the original owner to get them back.
Oh yeah.
Okay.
Absolutely.
Okay. Yeah, because I mean, if somebody stole my guns, it's a decent amount of money. I would definitely want them back.
Yeah.
Okay.
Any further questions? Seeing none, thank you both very much. Mr. Jocelyn, if you'd like to come up in opposition.
That didn't last long.
I told you so.
We're working on this as you see.
Thank you, Mr. Chairman. John Jocelyn speaking on behalf of 2A Maryland in opposition to Senate Bill 444. Gun buybacks are political symbolism. There's no hard evidence to prove that buybacks reduce crime or enhance safety. In point of fact, sometimes when a person takes a gun to a buyback, they're violating the law. Unless you have a carry permit in Maryland and you take a regulated firearm to a gun buyback, you are in violation of criminal law, criminal article 4-203, as well as 5-303 in public safety. FFLs will not participate in a gun buyback. There's no financial benefit to them. I have enclosed in my testimony some copies of PIAs to law enforcement agencies. These agencies admit they are not entering the serial numbers into the NCIC system, nor are they making any effort to return the stolen firearms. There is a penalty if you don't destroy the entire firearm, but that's totally unenforceable because you can't track what was or was not on that firearm. Nowhere did law enforcement ever tell me that they made an effort to contact the legal owner and return the firearm. They may identify it as being stolen or lost, but there's no requirement in this legislation that they make a good faith effort to return it to the lawful owner. Suggest the following amendments. Remove the reference to the FFLs because it's simply clutter. Keep the lost and stolen check requirement. Require that they be entered into the NCIC system. Add a requirement that law enforcement return the firearm to the lawful owner when they could be located, and delete everything else in the legislation. That's something we can get behind. Failing that, we must stand in opposition to Senate Bill 444.
Thank you, Mr. Chair. Can you elaborate about the violations in taking one of these regulated firearms to a buyback?
Criminal Article 4-203 stipulates various places you can take a firearm to. A gun buyback is not one of those places. In point of fact, recently, the Catholic Church sponsored a buyback in Baltimore City. It was advertised to be on a school property. I advised MSP of this and asked, is there any dispensation? They said no. I sent an email to the Archdiocese saying, you might want to consider looking at this. Here's the law sections for you. Their copies are attached. They changed the venue. They never said thanks.
Gotcha. Are these parts regulated in Maryland?
No, they are not.
Are they legally available?
Yes.
Are they available in retail stores?
Retail stores, through the internet, Bass Pro, Cabela's.
Gotcha.
I have a firearm as part of an estate that I have to deal with that is a stripped-down receiver. It was never built into a firearm by the original owner. I don't know how the agency receiving that firearm is going to document that what they received is missing a slew of parts. The slide, the barrel, a recoil spring, magazines, all of that. There's no paperwork requirement in this to be able to say, oh yes, we got this and it's missing this, that, and the other. I seriously doubt that anybody on a buyback knows how many parts are in a Glock, so they wouldn't know what is or isn't missing. Somebody turns in an old firearm, and I've seen plenty of them, people standing in line with their bits and pieces. How do you document that this screw is missing or that screw is missing? The language of the bill is absolute, each and every part that's attached.
How do you make it enforceable?
You can't. Because the agency that would do it would be the law enforcement agency, so it would follow the Maryland State Police because they won't do a buyback. So they would become the logical enforcement agency. And how they're going to monitor all these various police agencies across the state to participate, I do not know.
Right. Thank you, Mr. Chair.
Thank you, Mr. Jocelyn, for being here. So I'm actually reading a little bit of your testimony. Are you familiar, are you aware of any situation or occurrence where somebody was cited for violating a law because they brought a gun to a buyback?
I am not aware of it, but obviously no one wants to do that because of the chilling effect it would have on what their intent is, which is to get people to bring firearms.
Right,
if
but
they find out they're going to get busted they're not going to come in.
In fact, what you say is, what is not obvious is the chilling effect it will have on dealers and local law enforcement agencies because the firearms must be destroyed and their trade-in value is reduced to zero. So is the issue you have is that you're scared that people are going to get arrested for bringing in a buyback, or that they're not going to get the money for their trade-ins?
No, my concern is if we end up with language that says that any firearm that's traded in, and the original language years ago said that, they couldn't recycle their firearms to buy new ones from that same vendor. As far as the folks that are trading them in point of fact, having been to several for mercenary reasons, of course, I saw people who were there trading in junk that they'd collected over the years because they wanted to buy a new firearm and couldn't otherwise afford it. So they were trading in rusty old stuff that nobody wanted. And therefore, they got the money more than its street value. My wife's coworker, when she taught in the city schools, her husband passed, he owned the shotgun. She asked me to dispose of it. I tried to sell it for $125. No takers. Dropped it to $75. No takers. Dropped it to $50. No takers. Sheila Dixon did a gun buyback offering $100 for a shotgun. She bought it.
Okay. All right. So thank you. Thank you.
Senator Tomlinson?
I'm all right. Thanks.
Seeing no further questions for the panel, thank you very much. That concludes what? Delegate Boucher.
Thank you, Chair. Mr. Johnson, when these buyback programs are instituted, what percentage of them are long arms, and how many long arms actually get used in criminal activity?
Long arms are very rarely used, and if you look at the data that I have in the PIAs, you'll see that probably most of them are long arms.
Thank you very much.
Seeing no further questions, we thank you very much. That concludes testimony on Senate Bill 444. Going to Senate Bill 655 now. Senator Hester, please. This is sponsor only. You heard the bill once before. It's now passed over from the Senate.
Good evening, Mr. Chair. 655. For the record, Senator Katie Frey-Hester, thank you for your consideration. Mr. Chair, Madam Vice Chair, members of the committee. Senate Bill 655 is the cross-file to HB 966, sponsored by the wonderful Delegate Cardin, which the committee heard last month, so I will be very, very brief. This bill, you may remember, creates a fund to an AI evidence clinic pilot program within the Administrative Office of the Courts. It was an idea that Chief Justice Fader came up with. There was one change that happened to the bill before it crossed over to the House. The change is that it changes the program from an RFP process to a grant program. And so the bill now establishes a grant program in the Administrative Office of the Courts for these pilot programs, for the AI evidence pilot program. And basically the intent of the bill is because we have AI information coming into the courts don't have the expert witnesses themselves to tell what is real and what is fake. This pilot program will enable them to partner with the university, and the university will be able to support civil cases, especially where participants do not have access to legal counsel or expert testimony. And so with that, I would ask for your favorable report on the bill.
Questions?
The change, the one minor change is so that it reduces the fiscal note to basically to zero, correct?
So they still, the fiscal note this year is zero, but the way the clinics work, they do hire grad students. So next year it will be, I mean.
Right, but being a grant program, it's not mandated.
Exactly.
Right, got it, thanks.
Questions? Seeing none, thank you very much. That concludes 655. 360 is next now. And
I have two
there
witnesses,
are
Mr. Chair.
witnesses. 360, well, actually, I have just three people who are going to testify, one favorable with amendments, and one unfavorable. Senator Hester, Lisa Jordan, Jeremy Zacher.
I can be Jeremy, but I'm favorable.
Okay, Bill, Jeremy's opposed. I don't think you are.
Right.
We're going to hear from all three who are at the table right now favorable on the bill. That's fine.
Thank you very much. Once again, for the record, Senator Katie Frey-Hester here to present Senate Bill 360. This bill seeks to provide a civil remedies for victims and creates a misdemeanor for those who distribute a computer-generated visual representation that falsely depicts a person in a sexual manner. This bill passed unanimously out of the Senate last year and this year. Last year, due to slight differences between the Senate and the House versions, we ran out of time to get the bill over the finish line. This year, we have strengthened the bill with some changes, which I believe will address the concerns of the House last year. As you know, websites and apps that use artificial intelligence to generate sexual imagery have grown in popularity. And in the first half of 2024, AI-powered undressing websites, which create non-consensual nude images, collectively garnered over 200 million visits. The ease of access to these websites is facilitating the proliferation of fake imagery that is devastating to the lives of an ever-increasing number of victims. So how does Senate Bill 360 address this issue? It broadens both the existing state criminal and civil code by first defining these computer-generated visual representations as a visual representation created without using other existing visual representations and created using other existing visual representations of a person without the person's consent. It amends the existing misdemeanor revenge porn offense to apply to the distribution of these explicit computer-generated media under circumstances in which the possessor did not have the consent and did have the intent to harm, harass, intimidate, or coerce. Third, it enables victims to seek civil remedies through a private right of actions. These actions include, but are not limited to, monetary damages, restraining orders, and other relief deemed appropriate by the courts. And fourth, it enables further victim protections by restricting the availability of court-documented imagery from being viewed publicly. In closing, this bill will not end non-consensual computer-generated pornography, but it will strengthen protections for victims, addressing the risks posed by these new technologies, and ensuring that perpetrators are held accountable. And so for that, Mr. Chair and members of the committee, I urge a favorable report on Senate Bill 360.
Thank you. I don't want to repeat, exactly what the senator said. I'm here from the Women's Law Center as their executive director, and I applaud this bill because it does three things that the senator just talked about in one bill. There are current other versions out there that you've probably all become aware of, but this bill actually, as the senator said, amends the current revenge porn statute to now incorporate AI-generated images, which right now prosecutors are unable to prosecute in revenge porn cases when there is an AI-generated image because it's not in the law. So they have to turn away victims of these horrendous crimes. Oftentimes these are victims who have been in a relationship with someone, the relationship has ended, and now this is being used to embarrass, to humiliate, and to cause irreparable damage to them, not only their mental health, but also financial assets that they may have. They may lose a job. And so for those reasons, the Women's Law Center definitely supports this, as well as the injunctive relief that this bill allows for, because it does what the victim wants. They want the image taken down. So it allows for that injunctive relief, as well as with the civil remedies, attorney's fees, and it gives the victim power to bring a civil action to court rather than just depending on the state's attorney's office in a criminal action. So thank you for your time.
Thank you, Mr. Chair. Remaining 13 members of the Judiciary Committee. I'm Lisa Jordan with Maryland Coalition Against Sexual Assault. We are also here in support of Senate Bill 360 with a technical amendment. Senate Bill 360 is the fourth of the bills you have heard this session regarding deep fakes. An extremely skilled prosecutor pointed out to me that on page 4, beginning at lines 22 over to page 5, through line 14, there was a difficulty in charging in that it seemed to charge actual visual representations differently than computer-generated visual representations. So MCASA strongly suggests that you make both the computer-generated and the actual images and anything in between all defined as visual image. If you put it all under that same definition, I believe you will just be able to have the one charge. I've consulted with people who know more than I do about prosecution, and they do agree with me, as well as the skilled prosecutor who raised the issue with me. For those reasons, and with that one technical amendment, and for the reasons stated by the witnesses before me and all of the other hearings you all have already heard on this issue this year, we encourage a favorable amendment or favorable report with these amendments. Thank you.
Are there questions for this panel? I guess my fundamental question about all of these bills is it says that it has to be indistinguishable from another actual and identifiable person, but it also says it has to be computer generated. And on the criminal side of this, I have absolutely no idea what prosecutor is going to be able to use this.
So, Mr. Chairman,
How are they going to prove that it's computer generated?
Well, there are ways to prove that it's computer generated, and that's the issue, because oftentimes a witness will have to get up and testify that is my face, that is not my body. So that's the issue. Sometimes it is a distinguishable body part and a different face, so it can flip, but
how does that go to it being computer generated?
It can be computer generated. There's websites where you can go on there and take a face of someone and put it on a body of someone else doing a sex act that the face of that person never did. And I know Senator Hester had a terrible story about a juvenile, I believe, in high school last year who was a victim of this. And I believe the state's attorney's office in Howard County couldn't prosecute because it was AI generated. They were able to show that the victim can testify, that was not me. I did not do that sexual act. The victim can say, that is not my body. And, certainly these cases are going to be difficult for victims to testify about.
Yes.
But they will want to. And in a civil claim, too, having civil remedies allows them to pursue the civil action as well, those damages that can occur as a result of some very explicit, disturbing images of the person, their face, which is, indistinguishable. I mean, so I think it's important that we add this into our laws. 23 other states across the nation have done this because we have now seen with revenge porn this new use of technology.
How many successful prosecutions have there been?
We haven't been able to because the statute doesn't allow for that. They need this definition.
No, I mean in the other states. I mean, can you point to other?
I would get back to you with that if you'd like.
Great.
Yeah, I don't know what the statistics are.
Mr. Chair, if I might, in the child pornography statute, instead of having it separated out, so you have the actual images and then the computer-generated images in two separate sub-paragraphs, they just use an or. And I looked at it, and I believe I understand both your concern and that tweak of instead of having a separate, this is computer-generated, these are actual images. I think if you make it so you don't actually have to prove if it's actual or if it's computer-generated. You just have this image that was posted without consent. Who cares if it's computer-generated, actual, or somewhere in between? I believe that would solve the issue that you're concerned about.
I think it wouldn't necessarily obviate the need for the bill, but why doesn't it obviate the need for the bill if you just include that language? And it's just anything that looks like somebody any image that looks like somebody else.
Because I think as written right now, it only applies to actual images. And so what's excluded right now are the computer-generated images. So the defense is that's not an actual image. So this would clarify that it does include computer images. So it really is a much more simple bill in some ways. It's simply saying, image, whether analog or computer-generated.
Delegate Cardin.
I was actually going to ask that exact question, but I just want to clarify then, because I think you answered it. So the idea behind the bill is that it doesn't matter whether this is computer generated, whether this is something that was done with a camera, whether this is something that was drawn but to perfection so that it looks like it is, well, actually, I think you said it says if it's drawn, it's exempted.
It's correct.
But if it is,
indistinguishable.
Perhaps if it's using a application on a computer that somebody creates an image, it doesn't matter how it's produced, as long as it's an image of a particular person and can be proven, then it also is without their consent, and it's with the intent to harm, harass, intimidate, threaten, coerce, or and it is a sexual depiction. It shouldn't make a difference.
Right.
And
just so
it would
an
be
ordinary
included in the
person.
definition, and therefore it can be prosecuted. Is that the
That's,
understanding?
and an ordinary person would conclude that it was an actual identifiable person. And what you just described, Delegate, that's exactly the approach that's used in child pornography. So yes, you're absolutely
Okay.
correct.
So
It doesn't matter, however it's produced.
I will talk to the subcommittee chair, see if maybe there's an amendment necessary.
I believe that there's a subcommittee meeting on Friday at 2:30. I could be wrong.
There is. Are there other questions?
So maybe.
All right, I've had enough. That's the end of the testimony for Senate Bill 360. Thank you all very much.
Thank you very much.
Thank you. Senator King has been very patient. Sitting next to Senator Kramer, who looks like he could spit bullets, but just hang in there. We're getting there.
Chair Clevenger, there was opposition to 360.
Oh, I'm very sorry. That's right, there is. Sorry, Senator King. We have the public defender, the person who, yeah, it's the person who's clearly not a visual representation of Judge O'Malley. All right. Let's go.
Thank you, Chair
Public Defender's
Clevenger.
Office.
Good evening, everyone. My name is Jeremy Zacher. I'm Assistant Public Defender in Baltimore City. The Office of the Public Defender asked for an unfavorable recommendation on Senate Bill 360. The proponents of the bill say this is about AI-generated imagery and AI websites. However, nowhere in this bill, in the statute, will you find the term AI or artificial intelligence. It talks about computer-generated images and says a computer-generated image can be image generated from nothing, from out of thin air, or an image generated from a previous image, which basically includes everything. Computer-generated imagery is a wide category of imagery. If you think about the way we do imagery today, pictures, no one does film anymore. Everyone does everything with a digital camera. And edits to pictures take place digitally. If anybody has ever done wedding photos and your wedding photographer touches you up a little on their computer, that is a computer-generated image. And so the definition they give for computer-generated images is overly inclusive because it can include anything that touches an image, but it also may be under-inclusive because it excludes drawings. And one can draw an image on a computer, and one can draw an image to be indistinguishable from a real person depending upon how much drawing is done and the talent of the individual. So as this definition makes its way into court, we could run into a due process problem because of its vagueness and it's just breadth. It may fail to put people on notice of what a computer-generated image under the statute actually is. The bill does allow for a civil remedy, which the Office of the Public Defender thinks is the more appropriate place for a defamation action. This creates defamation per se. The idea of revenge porn is inherently trying to damage someone's reputation amongst the community. Historically, those types of actions have been held in civil court, and this body could seek remedy in civil court before jumping into the criminal realm. We're asking for an unfavorable.
Questions to the Office of Public Defender? Not yet to Senator. All right, seeing none, now we're done with that bill. All right, we're done with Senate Bill 360. We'll go to Senate Bill 710, Senator King. It is sponsor only. I think she has help if she needs it.
Yes, if you
From
have any
Montgomery
questions I
County.
can't answer,
All right.
I have help.
Okay.
Mr. Chairman and members of the committee, Senate Bill 710, which was unanimously passed by the Senate, is a cross-file of House Bill 883. As drafted, the bill was written to Section 3-212.1 of the criminal law article. For clarity, the Judicial Proceedings Committee amended the bill by adding a new section to the criminal law article 3-212.2. In doing so, it separated criminal negligence with a vehicle from criminal negligence with a vessel. Under current law, we address criminally negligent conduct with a motor vehicle once that conduct has caused a life-threatening injury. Senate Bill 710 will address criminally negligent operation of a motor vehicle before the conduct results in a life-threatening injury. People who disregard the rules of the road and operate their motor vehicles in a dangerous and deadly way need to be held accountable, and I respectfully ask for a favorable report on Senate Bill 710. Mr. Chair, I am offering an amendment to correct a typo in the bill's title. It should read the Sergeant Patrick Kepp, K-E-P-P, not said Sergeant Keep.
Are there questions for Senator King or for Councilwoman Lutke, who is here riding shotgun with her on this bill? And now you guys go quiet. Thank you all very much.
Thank you.
That concludes
must be
Senate Bill
unanimous.
710. All right, going to keep rolling through the rest of our senators here. Sorry to our friends from the administration, but, you know, we're doing the best we can. Senator Augustine is here on Senate Bill 608. And on an issue with it where I believe he has had some contact with Delegate Embry a little bit.
Yeah.
About U visas.
Thank you. Thank you, Chair Clippinger, Vice Chair Bartlett, and members of the committee. Senator Malcolm Augustine here on behalf of Senate Bill 608, which does have similar elements to House Bill 579 as presented by Delegate Embry. The differences are that 608 really does pertain to the U non-immigrant status petition. And of course, House Bill 579 has incorporated the sensitive locations language into it. And as you heard from Senator Chair Smith previously of Senate Bill 828. As it relates to the differences between the two bills, the House Bill 579 and Senate Bill 608, there are some technical differences that are there. And we also in Senate Bill 508 include conviction and sentencing in the as in instances to be considered helpful of a qualifying criminal activity. And Senate Bill 608 also put in establishing a rebuttable presumption that includes reasonableness of cooperation on helpfulness as far as in that definition. And then Senate Bill 608 also requires either the certification of declining of the certification in 45 days instead of the 30 days that you all put into the bill, and that was at the request of some of the certifying entities. I would ask for a favorable report on Senate Bill 608 and happy to answer any questions that you might have.
Questions for Senator Augustine? Okay. What? Seeing none? All right. Thank you very much, Senator. Thank you very much. Let's get Ben Kramer up here. Senator 80, Senate Bill number 80. No whistling and catcalling yet. Not yet.
Give it a couple minutes.
Siri wondered whether there was an app for catcalling Senator Kramer. Never mind.
Well, good evening, Mr. Chair, Madam Vice Chair, members of the committee. Ben Kramer here introducing Senate Bill 80, and I will share with you during the course of this afternoon, I was having flashbacks to my time on this committee 20 years ago, and I suspect there's going to be a Xanax in my future this evening. Colleagues, let me quickly explain the issue that had been brought to me that this bill seeks to resolve. Both my state's attorney in Montgomery County, John McCarthy, and a couple others have brought up the fact that we have a small gap in our law with regard to animal abuse. We have a section 10604, which is abuse or neglect of animal, and then we've got 10606, which is aggravated cruelty. The gap is aggravated cruelty deals with the intentional severe harm of an animal, but the problem, and it's not frequent, but it does occur, what happens when an animal is so badly abused that when law enforcement find the animal, it's still alive, but there is no alternative but to put the animal down, to euthanize it. There's no chance of saving the animal. And under current law, that would be prosecuted under the lesser charge of abuse or neglect, as opposed to the more severe aggravated cruelty, because that requires the intentional killing of the animal. So the bill before you, as amended by the Judicial Proceedings Committee in the Senate, creates a subsection to 10604. It creates 10604.1, where in the event the animal has to be euthanized and certified by not one, but 2 licensed veterinarians in the state as there was no alternative but to put this animal down, then there is an enhanced penalty. It does not get to the level of the aggravated cruelty, but it's a little bit higher than that of the abuse or neglect. It remains a misdemeanor up to 1 year with a penalty of up to $5,000, but most importantly, it affords the court the opportunity to prohibit that individual from having a domestic, and the way the section is worded, a domestic animal or livestock. So typically the issue has been with horses. By the way, our friends from Harford County had come in previously to support this bill. And with that, I would ask for a favorable report. Again, Mr. Chair, it doesn't happen with great frequency, but when it does, there is this gap that we can fill.
Questions? Vice Chair?
Thank you. Thank you for your patience today, and thank you for bringing this bill. I get it. 2 questions.
Yes, ma'am.
I'm assuming that the penalty is the same, and I didn't look it up, I'm sorry, but is the same if the action, is the same as the intentional action that results in a death?
No, the intentional action, that would be under the aggravated cruelty. That is a felony, and the penalty is up to 3 years and a 5. So this is a much reduced penalty, but it is higher than the abuse or neglect.
Okay, I see that now. Thank you. And last question is the last section saying that it is an emergency measure?
Madam Chair, that is the work product of the Judicial Proceedings Committee. It did not come in the way. That bill it wasn't introduced as an emergency bill. However, the Judicial Proceedings Committee, in its wisdom, chose to add that language and make it an emergency bill. Okay. I can't address the logic to it. I was not privy to that conversation, but that is the way it was amended and reported out. And if I may also, Mr. Chair, pass unanimously both in committee and off the floor.
Delegate Simpson?
Quick question is, check with like animal control and find out whether or not the 2 veterinarians, like, is that an unrealistic burden?
Well, it's a challenge, but the judicial proceedings, in its wisdom, felt that the bill as introduced had a licensed veterinarian. They felt that as a safeguard, that they would amend the bill so that it would provide for 2 licensed veterinarians to, and quite frankly, when I spoke with a couple of my friends with the state's attorney's offices, they felt that that would not be overly burdensome and that they were comfortable with that amendment adding the second.
So they would have to actually examine the animal, or could it be like, I don't know, I guess.
I believe it would require examination to determine that.
I just wonder all throughout the state how realistic.
I think generally speaking, there are licensed veterinarians throughout the state at a level where it could be accomplished if the state's attorney's office chose to prosecute, that, you know, under this circumstance, they could in fact find 2 licensed veterinarians. And it could be that it might be within the same hospital that 2 of the veterinarians working in that hospital, because typically speaking, that's where often these animals are rushed to as they're trying to save it. Again, at a prior bill hearing, we heard from a number of the state's attorneys, some of the cases they have had, and they're pretty gruesome and very sad to hear, but they did try saving the animals, but it was to no avail.
Okay, thank you.
No, thank you for the question.
Other questions? Delegate Crutchfield.
Hello, Delegate Crutchfield.
Thank you, Mr. Chair, and hello to you, my favorite senator. Isn't that so?
Thank you for that.
All right. That's enough of that. All right. Thank you very much.
I'm enjoying visiting here.
All right. Well, we hope you enjoy your Xanax later. Thank you very much. That concludes the testimony for Senate Bill 80. We're going to
have a great evening, committee. Thank you, Mr. Chair. Thank you, Madam Vice Chair.
Going to put the Department of Transportation at the table now, please.
Ain't that the tree?
Next to last one. From MVA? Hello? There you are. Great. Senate Bill 207.
Yes, good evening, Mr. Chairman. For the record, my name is Christine Iser, Administrator for the Motor Vehicle Administration, and I'm here to testify in support of Senate Bill 207. The committee has heard its companion bill, which is House Bill 70, so I'm just going to go over the amendments that were put on by the Senate. As a reminder, this bill would revoke the driver's license for an individual convicted of driving under the influence of alcohol or drugs for a period of 5 years if that crash contributes to death or life-threatening injuries, and also apply to drivers who fail to remain at the scene. In terms of the amendments, the first one, while the standard revocation period would remain at 5 years, customers who are experiencing undue hardship or extenuating circumstances may file for reinstatement at a 2-year period and request that. Second, the bill no longer applies to customers who are given probation before judgment. That's been removed from the bill. The third amendment applies to hit-and-run crashes so that the 5-year revocation applies to crashes that result in serious bodily injury. That uses a consistent definition that's already in the transportation article. And finally, the last amendment strikes the ignition interlock requirement on page 5 that came up actually in our bill hearing here in the House. And that's because not all hit-and-run crashes involved alcohol, so we agreed to remove that requirement as well. Our goal is obviously safer roads, but we think that with these amendments, it also balances the driver or the individual who's trying to get back to driving's ability to understand what the rules are, what the requirements are, and to have a fair process as they move through. For those reasons, I respectfully request a favorable report on Senate Bill 207 and happy to answer any questions.
Seeing none. Thank you very much for putting up with this all day today. Thank you very much to the people in the back of the room, too. All right, Senate Bill 400. Senator Giles' staffer is here. This is Senate Bill 400. Some members of the committee might remember a relatively interesting throw pillow associated with testimony on this bill when we had in the House. So please go ahead.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Spencer Dixon, Legislative Director for Senator Dawn Guile, here to present SB 400 on her behalf. As the chair indicated, this is the cross-file of HB 497, which, among other things, would prohibit youth transportation companies from using physical or mechanical restraints on children during transport, except in cases where there's an immediate risk of serious physical harm to the child or others. Per the fiscal note, SB 400 does not have a fiscal impact. And as I mentioned, the cross-file is HB 497, sponsored by Delegate Stewart. And that was heard on February 13th. I have submitted to this committee an amendment, SB 400/313420/1, that was drafted in consultation with Delegate Stewart's team and Disability Rights Maryland. Additionally, I understand that Delegate Stewart has worked directly with this committee on additional amendments that would make the bill even stronger, and I believe those should be in the committee's system. It's HB 497/103/721/1, Senator Guile welcomes these amendments along with the one we submitted to the committee, and with that would request a favorable report on SB 400 and HB 497.
The committee's information, this legislation is going to go to the Family Law Subcommittee run by Delegate Crutchfield, who has her light on. Delegate Crutchfield.
Thank you, Mr. Chair. So, Spencer.
Yes.
I wanted to make sure that I understood the amendments. So you mentioned, did you mention 743328/1?
So,
Yes.
and thank you for the question, Delegate. I believe there were several issues that were spread across, I believe it's 3 amendments in the House, and they were combined into the third reader of the bill you have, plus the 2 amendments, but they should conform when they all come together.
Okay, all right, because I want to make sure I've got them all.
Yeah.
And I think that the majority of the amendments are from the Disability Rights Maryland folks?
Yes,
Okay.
that's right.
All right, okay, I just want to make.
Along with responses to some questions that delegates had during the hearing.
Okay, got it, okay. All right.
Okay.
Yeah.
Questions? Any other questions? Delegate Kaufman.
Thank you, Mr. Chair, and I believe you alluded to this, but there's so many bills in my head, so bear with me. My question is, you mentioned trying to accommodate Disability Rights Maryland. So I was wondering if you were in agreement with them that the bill should cover the Department of Human Services and its local agencies, as well as and contract transportation companies, in addition to who's already covered in the bill. And if you don't know, you can certainly contact the committee later after you ask the senator.
Thank you for the question, Delegate. In Senate Finance, there was an amendment applied that was meant to provide a specific carve-out to just the time restriction for DHS, and I believe the way that it was drafted was broader than that. The amendments that have been submitted by Delegate Stewart resolves that issue to my knowledge.
And it resolves the issue of physical restraints as well?
That's right.
Thank you.
Thank you for the question.
Thank you, Mr. Chair.
Other questions? Seeing no other questions, we thank you very much. That concludes testimony on this last bill and concludes testimony for the House Judiciary Committee today. We'll be back tomorrow with another relatively long list of bills, but that'll be it for the hearings probably. And we'll start voting not long after that. Thank you all very much and have a good evening.